Greetings to everyone. I, Manik Singhal, warmly welcomes you all to the South Asian Global Intellectual Property Conference 2025. This conference is being organized under the second South Asian Global Intellectual Property Summit 2025 by the Center for Development of Intellectual Property and Research under the aegis of Naovina Development of Intellectual Property and Research Foundation in collaboration in global collaboration with Cambridge Teachers of Tomorrow, the Global Entrepreneurship Network, the Global Innovation Policy Center, and Internet Governance Forum. This conference is not merely an academic gathering. It is a global platform for dialogue, collaboration, and critical engagement at the intersection of law, innovation, governance, and technology. It brings together scholars, policymakers, professionals, researchers, and students to explore emerging challenges, contemporary developments, and future opportunities in the evolving domain of intellectual property rights, particularly from South Asian and global perspective. Now introducing the organizer. The Center for Development of Intellectual Property and Research is India's first non-governmental research organization dedicated exclusively to intellectual property rights. Functioning under the Naovina Development of Intellectual Property and Research Foundation, a Section 8 non-profit organization, CDIPR works towards advancing IP scholarships, strengthening policy discourse, and fostering innovation and creativity across sectors. Through research, academic collaborations, and global engagement, CDIPR continues to play a key role in shaping IP through leadership in India and beyond. We also have global collaborators with us. Cambridge Teachers of Tomorrow is a global recognized academic initiative focused on advancing education, research excellence, and future oriented learning. Through international academic collaboration, it works towards strengthening teaching standards and promote interdisciplinary scholarship across borders. Global Entrepreneurship Network operates in over 200 countries with the mission of making it easier for anyone to and scale a business. By fostering cross border collaboration between entrepreneurs, investors, policymakers, and ecosystem builders, strengthens entrepreneurship ecosystem worldwide. The Global Innovation Policy Center is a leading global think tank dedicated to promoting innovation driven growth through strong intellectual property frameworks. GIPC works closely with governments, industry leaders, and academic institutions to advance evidence-based IP policy and support innovation-led economics. The Internet Governance Forum is a global multi-stakeholder platform convened under the United Nations to facilitate dialogue on public policy issues related to the Internet. The IGF brings together governments, the private sector, civil society, and academia to promote inclusive, secure, and sustainable Internet governance. This year's conference stands as South Asia's largest, most impactful, and most prestigious intellectual property conference, marked by its international participants and world class academic collaborators. Selected papers from this conference will be published in an internationally rated volume, Global IP Transformation, Legal, Technological, and Cultural Dimensional from South Asia. Next, I'm honored to welcome our esteemed panel judge for the day, Mr. Dipendu Das. Mr. Das is the director of the Center for Development of Intellectual Property and Research. He is an distinguished figure known for his contribution to academia, public policy, legal research, and literature. He is also the founding co-convener of the Indian Center for Child and Human Rights. Under his guidance, the Center for Academic Research and Excellence was established in September 2023. With an extensive background in research and public policy, Mr. Das has made a significant impact at both national and international levels, with his works published in more than 16 countries worldwide. We are honored to have you with us today, sir. Moving on to the presentation guidelines. All presenters are requested to kindly note that they will be given a total of 6 minutes, out of which 5 minutes are allotted for the presentation and 1 minute will be reserved for the question and answers. Presenters are requested to keep an eye on the comment box during the presentation to track time. Please also ensure that your microphones and cameras are working properly. With that, I warmly welcome you all to today's conference and invite our first presenter to begin. For our first presentation, we have Anisha Day from Sister Nivedita University.
Am I audible?
Yes,
Yes,
you are.
yes, you are audible and visible.
Um, Sir, I have a problem with my laptop. So, can I present my paper without PPT? Please give me the permission.
You don't have your PPT right now with you.
Yes, I have, but my laptop is not functioning properly.
Okay, you have to share your PPT immediately after this presentation. You can start with your presentation. Kindly stick to the timer.
Okay. Okay. Sure. My paper title of my paper is that evaluating the recognition of the non-conventional trademarks in the India trends and challenges in judicial interpretation. Good morning, all judges and all. I am presenting now of the topic. Trademark laws plays a vital role in protecting brand identity and consumer trust. Traditionally, trademarks included names, logos, brands, and symbols. With evolving marketing strategies, businesses now rely on non-conventional trademarks such as sound mark, smell mark, shape mark, color mark, and motion marks also. This presentation examines how Indian law and courts recognize such marks and the challenges involved. Firstly, I point out that meaning of the non-conventional trademarks. Non-conventional trademarks are marks that do not fall within the traditional visual representation. Example include sound marks, example jingles, shape marks, example product packagings, new types of product packagings, color combinations, motion marks, mail and taste marks. These marks appeal to sales beyond sight and enhance brand recall. Then I come to the point of legal framework in India of the non-conventional trademark and trademark also governed primarily by the Trademark Act 1999. Section 21ZB defines a trademark as a mark capable of graphical representation and distinguishing goods or service. The requirement of graphical representation poses a major hurdle for non-conventional trademarks. Indian law does not explicitly prohibit such marks but applies strict standards. Types of non-conventional trademarks recognized till now. Sound marks. Yahoo Weddle first sound mark registered in India. Shape marks. Coca-Cola bottle shape. Color marks rarely accepted unless strong secondary meaning is proved. Motion marks still underdeveloped in India. Smell and taste marks are also not yet recognized due to evidentiary difficulties. Then we come to the point judicial trends. Indian courts have gradually shown openness towards non-conventional trademarks. Emphasis is placed on distinctiveness, consumer association, non-functionality. Courts remain cautious to avoid granting monopolies over functional or generic feature. Key judicial decision about I point out some case laws. Gorbatsky Vodka KG versus John Bisty Leaders Limited, Bombay High Court 2011, court said that distinctive bottle shape and trade dress as protectable non-traditional trademarks. Then Yahoo Inc. versus Akash Arora. In this case, domain name functions as trademark and are protected against passing off. Then two foreign case laws I point out: Sigman versus Diotis patent and Qualitex Co. versus Jacobson Products Co. US Supreme Court 1995. The court ruled that single color can be registered as a trademark if it has acquired distinctiveness and is non-functional. Practical challenges about non-conventional trademarks evolution and recognition. Challenges are difficulties in graphical representation of non-visual marks, high evidentiary burden to prove distinctiveness, and lack of technical expertise at the trademark registry, inconsistent examination practice, and limited awareness among businesses about non-conventional trademarks. Then, comparative perspective: India, US, and EU. In US, no strict graphical representation requirement about border acceptance about non-conventional trademarks. Then European Union allows non-traditional marks if they are clear, precise, durable, and objective. India remains more conservative compared to this jurisdiction. Need for reforms about the non-conventional trademarks recognition and evolving. Relaxation of the strict graphical representation requirement, adoption of the technical tools or examination requirement, clear guidelines for registry official, increase judicial clarity and uniformity of the and proper predictability of the non-conventional trademarks and awareness program for the business and practitioners. Then I conclude my topic. India is slowly evolving, is recognizing
Participant
non-conventional
move to
trademarks.
the participant move to the recommendations and suggestions.
Okay, and the recommendation and suggestions of this my topic is that India is slowly evolving recognized non-conventional trademarks. I recommend the relaxation of strict graphical representation of requirement, adoption of proper technological tools for examination, and clear guide and give the clear guidelines for registry officials. Because of registrability of the trademarks is the most vital point of the recognize the trademarks, increase judicial clarity and informity, and also recommend the awareness programs for businesses and practitioners. And in this conclude this point, a balanced approach is required to protect innovation while preventing unfair monopolies. Because of monopoly is the vital point of the preventing the trademarks recognition. Legal reforms and judiciary consistency can strengthen India's trademarks regime in the modern commercial landscape. That's it. Thank you so much. I am happy with any question has come.
Okay, participant, you had mentioned a domain name sometime are being recognized, and later on, any if any disputes arises, a passing over are provided. What in non-conventional trademarks, the significance of domain name nowadays? Like how we can come up and imply the domain name for the trademark registration?
Domain name trademark registration. I point out the case law Yahoo Inc. versus Akash Arora. In this case, I found the domain name function as a trademark as a are protected against passing off. In this case, Akash Arora works on the Yahoo, and he he just misused the domain name deceptive similar to Yahoo Inc. So Yahoo domain name is the domain name is the proper Yahoo India or Yahoo something else. This is the domain name is the misused. So it is protected properly. Domain name the for passing of Yahoo Inc. versus Akash Arora case. We see this, and it is my point also.
All right, we can move ahead with the next participant. Thank you.
Actually, sir, I have a question. Amiki, actually, have I sent the PPT on someone? Uh, actually, I
You
have
can,
PPT, but I thought.
you can send the PPT directly to the organizer's mail ID. Okay.
Okay, okay. Thank you so much. Thank you so much for opportunity.
Next up, we have Anne Johnson from Government Law College. Anne Johnson, please turn on your camera and your microphone.
Thank you, sir. Am I visible and audible?
Yes, you are.
Just give me a second. Let me share the screen. So, is my presentation visible?
Yes, it is.
Thank you. So, good morning, everyone. So, today I'll be presenting my research paper titled The Afterlife of Digital Works, a legal inquiry into the posthumous ownership in the modern IP landscape. So, human lives have increasingly becoming digitalized, and as of 2025, we have around 74% of the world coming online, and out of this, around 68.7% of them are also seen in social media. Let's take the example of India. Coming to India, we have around 900 million internet users as of 2025. So, this migration of human lives has created an unprecedented volume of digital works, and this creates an actual legal challenge. That is, what happens to a creator's intellectual property after his death? So, looking at the current legal framework, the current laws are designed for tangible assets and they are ill equipped for the digital creations. So, the objective of my research paper is to explore the legal and structural reforms that are necessary to bridge the gap between our digital lives and our posthumous digital ownership rights, ensuring that a creator's legacy is preserved and managed according to clear, predictable, and equitable principles. So, the methodology that I have used here is doctrinal analysis. So, first of all, let us understand what digital assets are. Digital assets can be simply defined as any information that is stored in the digital format and it is uniquely identifiable and capable of being used by the organizations to create value. Examples includes audios, videos, logos, etc. So this can be broadly categorized into two. It could be a creative and artistic content such as recorded music, digital art, photo collections, etc. All those they are having economic and cultural values for heirs. The second category is basically digital archives and communications, such as social medias, blogs, emails, that forms a significant part of a person's legacy and public memory. So there has been a steadfast increase in the content creators globally. Looking at the data, we can see that there is nearly 200 billion content creators market value in 2025, and it is also projected to triple by 2030. And thus, there is a hike in the professional and aspiring creators. So, as social media has grown, so has the number of accounts belonging to deceased users. So, this gives rise to a new phenomenon known as digital graveyards. As of 2018 report, it has projected that Facebook could have over 4.9 billion deceased users by 2100 if growth continues. So, potentially, deceased users would be exceeding living users in the 22nd century. Moving on to the challenges, the major challenge here is that digital works basically differ from traditional property. Their existence is often platform dependent, it is intangible, and it is governed by complex rights. Law always focuses on physical possession rather than digital access. Also, there is a legal uncertainty. That is, the traditional IP and succession laws do not expressly classify digital creations as inheritable property. Also, there are unresolved questions regarding moral rights and privacy. So let's look into India's legal land framework. So looking at India's legal system lacks a coherent framework for posthumous digital ownership. So we have outdated succession laws, that is the Indian Succession Act of 1925. It does not recognize intangible digital assets as inheritable property. Also looking at our IT Act, the IT Act, though it is focusing on electronic record, it does not validate the inheritance rights. Looking at platforms' terms of service of platforms such as Google fill this legal vacuum. However, they create opaque and inconsistent policies that override inheritance principles. So this is all about India's legal land framework. Let's move on to US and European Union. So looking at US, as you can see in the point section, US has basically adopted a contract-centric model. Accordingly, here in the US, the digital works are considered as inheritable under the copyright law. But the problem here was that the platform's terms of service often overrided succession rights. As a result, the Rufada Act was introduced in 2005. That is basically the revised Uniform Fiduciary Access to Digital Assets Act of 2015. And this gave importance to the user's intent. So user's intent was prioritized and it shall override any other terms of service by platforms. So it introduced a tiered access where users' rights were users' intents were given most priority. Coming on to the case of European Union has always given importance to universal succession of digital assets, and accordingly, the courts override platforms' terms of service. Also, moral and statutory interest of heirs are given more importance. Also, there are several court precedents where we can see that
Participant
the
move to the recommendation.
yes, sir. So, coming to the recommendations part, I have proposed a three-pillar reform framework. The pillar one, we have to focus on legislative recognition. Here, first of all, we have to recognize the digital assets as inheritable property. Secondly, we have to amend the succession and property laws. And thirdly, we should also give legal recognition to digital wills. Moving on to pillar two. Pillar two is for user empowerment. So for that, we have to introduce standardized digital legacy tools. We have to introduce a digital asset management system. We also have to introduce some proactive measures to ensure digital estate planning. Moving on to the pillar 3, this is to ensure transparency and platform accountability. So accordingly, just like the European Union DSA, that is Digital Services Act of European Union, so, such a similar style has to be adopted. Also, there should be some transparency reports that we have to get periodically from these platforms. Also, there should be some clear terms of service from platforms and data portability for health. Apart from that, we can also adopt some additional measures such as international harmonization through some international treaties, and also we can create a digital estate authority for ensuring governance. So that's it. The digital migration has made posthumous legacies invaluable yet legally precarious. India's gap highlights the urgent need for reform so as to bridge the legal chasm, preserve public memory, and honor creators' vision. So that's it. Thank you.
Okay, participant, you had mentioned a posthumous work. Like, what is the current legal status of a digital artwork where the artist dies before the expiry of the copyright? So, whether its ownership would be transferred as the succession right is concerned in India, or it would be transferred as per the IP, like legalization, the wills, or all this which is existing today.
Sir, as per my knowledge and my research, there is no any explicit law in India that is specifically stating anything regarding digital assets. So, succession laws or IT laws or IP laws are not recognizing the digital assets, and hence, such transfers and such activities are not explicitly stated anywhere in the legal framework.
So, like, if the creator or the owner of the digital artwork dies, the copyright lapse there, and no one is the owner at that point of time. Is this what you are stating?
Sir, we have Section 57 of the Copyright Act that gives importance to moral rights. So, accordingly, as per the
But moral
Section 57,
right, but moral right is an individual right. If the individual dies, the moral right stops there.
yes, exactly, sir. There is some uncertainty over there, and that's why I'm proposing these reforms.
Try to include uh, the legislative suggestions. You can have the review of the DPIT's recent drafts of recommendations to the government. Try to read those materials and include it.
Okay, sir. Sure.
Yeah, we can move ahead with the next participant.
Thank you, sir. Thank you.
Up next, we have Anshpriya Srivastav and Ankit Kumar from Chanakya Law University.
Yes. Am I visible and audible?
Yes, you are participant. Kindly share your presentation.
Yes, sure. Is my screen visible?
Yes,
Yes,
you
your
can.
screen is visible.
Good morning, esteemed judges and fellow delegates. Me and my co-author Ankit Kumar will be representing our paper on who owns the mind, intellectual property and ownership rights over neural data and brain-computer interfaces outputs in the age of neurotechnology. First, we invite you to look at the question, does your mind belong to you? Now, it may sound like a philosophical question, but neurotechnology is making it a pressing legal crisis. Neurotechnology, particularly BCIs, this reflects a rapid convergence of neuroscience, AI, and digital systems. These technologies were originally developed as therapeutic tools, enabling individuals with neurological impairments to communicate and interact with the environment. However, BCIs today extend beyond their medical use. They are increasingly used for creative expression, communication, and also in commodification of neuromarketing. Brain activity can now be translated directly into text, images, and executable commands. This shift fundamentally blurs the boundary between machine generated output and human authorship. This convergence it has allowed the BCIs to develop and translate the brain activity, which is the neural data, into executable outputs. Neural data occupies a unique space between biology and cognition. Apart from traditional biometric or personal data like fingerprints, this data is dynamic, predictive, and deeply tied to identity and autonomy. Existing intellectual property regimes or the legal frameworks which are presently available, they presuppose human authorship and external manifestation, and they struggle to address the outputs mediated through algorithmic decoding of thought. Neural data consists of the electrical patterns which are generated. At this point, the problem is no longer a technological one, but a conceptual one. Because once the thoughts become data, the law must decide what kind of a neural data exactly is. Beyond medical context, neural data is increasingly used in emotion recognition, attribution tracking, advertising, and gaming. This expansion raises a foundational question. Is neural data personal data, biometric, or some hybrid form? Why neural data cannot be treated like any other data? It differs fundamentally from personal data because it is a dynamic one and it is capable of revealing our emotional preferences. Existing data protection laws such as GDPR and India's DPDB Act, it does not explicitly regulate brain data as a distinct category. The traditional IP law, it also falls short because the neural data is legally distinct because of its sensitivity. This blurs the line between thought and expression. When creative works are produced through neural intent, it is unclear whether ownership lies with the user, the system developer, or both. For example, consider the case of a paralytic artist who develops his art using the device of a BCI interface. Then there is a question whether the ownership lies with that artist or the system developer or the one who analyzes the particular algorithm. Now, during the comparative analysis, we also see that BCI, it combines in the United States Patent Trademark Office, it maintains that inventorship must be attributed to natural persons. However, the European Union follows a similar approach to the USPTO with rejecting AI inventorship claims in cases involving the Davos system, which is identified in the Thaler case. Meanwhile, China has been a consistent leader in this BCI technology, and it has classified neural information as sensitive data under its personal information protection law, though specific protections remain underdeveloped. Now, when we move to the specific jurisdiction of India, the intellectual property framework faces
Participant
jurisdiction.
move to the suggestions and recommendation.
Okay, sure, sir. Sir, now I invite my co-author Ankit to present a proposed solution on how these existing legal frameworks fail.
Thank you, Hans. So for the recommendation, we have operationalizes a three-tier governance model. First, user ownership, where individuals retain inalienable control over their neural data and inferences. Second, custodianship, where developers act as duty-bound custodians rather than owners. And third, processing rights, which are narrow, purpose-limited, and fully revocable. Developers may protect their decoding systems, but individuals control how their thought-derived outputs are fixed, shared, or commercialized. Safeguards such as neuro impact assessments and transparency must be built into the system by design. Sustainable innovation, particularly in India, requires neurotechnology specific safeguards that treat the mind as a protected legal domain rather than a commodity. If the law allows the mind to become a commodity, autonomy becomes the casualty. Thank you.
Okay, this topic seems to be very interesting when we looked into the neurotechnological aspect. Now, tell me, when we looked into the neuro data or neurotechnological databases, it is an individual personal right towards the person attributes towards it, because my neuron system or the my information has been utilized throughout my experience. It's not about what I perceived; it's about my experience, which has been stored for years, right?
Exactly.
Yeah.
So
Yes.
when my this experience is stored in the form of information, my question to you, whether it would be like an intellectual property or a data which is related to a digital personal data, how it should be protected to get a maximum protection.
So this is not something which is regulated by intellectual property or the recent bill that has announced, personal data bill. So it is beyond that. Like it talks about the agency. Like it is not the output or innovation, it is the inner work which draws that output or innovation. So
And
we have to
yes,
make a specific law of specific rules and make some changes for this.
Is there any
and
country
so
which is working with it, like specifically
Yeah.
having their own rules and regulations on neuro data?
Yes, recently Chile has passed some regulations, and also state of America. There also have been some regulation have been passed about the neurotechnology data.
yes, sir. So the US state of Colorado, it has also issued guidelines regulating neural data as personal information. And the question which you posed earlier, if we see the existing frameworks, the problem of consent is a broad one. Because if I am a
See,
person who is using,
problem of consent,
yes,
it's not an issue because first at all, the person who is allowing his or her neural data to get transferred into an information, it's itself a consent which is being provided in a prior hand. I am aware
yes,
that my neural data is being used for being transferred, which means I am allowing it specifically, right? There is no separate elaboration required from my side, like when my data is being transferred. Now,
So
yes,
like my question towards it is specifically like you guys, the topic is good, but the linkage towards the conclusion and recommendation, it needs a precise form or findings. You can stuck with the question whether neural data can come to the definition of personal data, or it can be covered within the IP framework. That should be the question of your paper. Work on it. Thank you.
yes.
okay,
So,
thank you, sir.
thank you,
We
sir.
can move with the next participant.
Next up, we have Bhavya Mittal from Baba Saheb Bhimrao Ambedkar University.
Good morning. I guess my PPT is present.
Yes, it's visible.
You can start your presentation.
A very good morning. My topic is AI generated inventions and the patent inventorship in India. The issue about whether the patent should be granted to an AI generated invention started with the question which arises in the 2021 by the South Africa, where a AI system named Devis has been granted patent for the invention of the paperless container. But in 2022, the U.S. Federal Circuit Court in a Thello versus Vidal case said that the only humans can be inventor and rejected the decision by the South Africa. Same UK court also rejected this. Even the Japan just proposes an inventorship framework. There is no concept that it patent whether the patent should be granted to AI or not. Now the concept here is whether in what's the stand of India in this concept. So as we can see that section 2 2 clause 1 and y, and section 6 of Indian Patent Act 1970s presumes that a natural person is a human, that a human can only be only be can a human can only a inventor, not anyone else. There is no provision for AI generated invention, no autonomous inventions, that even AI don't qualify for inventions by patent office. So the thing is that the patent office, even we don't have any guidelines regarding, as recently in Japan the guidelines regarding patenting for the AI inventions have been given, but in India there is no supply. So as it's seen, when you can't provide a patent to just the AI generated inventions, that inventions falls in the category of trade secret, and many of because of that the concept that the because of that very few inventions came into public domain and leads to a issue. So what can we do with this? We can have some policies option in India. First is status quo and guidance, where a status can be provided. Status quo and guidance, which is fast but taken and inconsistent at even inventorship where we can consider the Article 27 of TRIPS agreement, which specifies that there is no differentiation between who can be inventor. There is no technological differentiation. Sui generis regime, we can make a particular law where we can talk specifically about AI related inventions, but this takes very long time and literally a very slow process. And the fourth option is we can have an innovation oversight. Innovation oversight. This concept of innovation oversight means that we have AI which will be helping a human oversight. And that oversight does not mean that he just open an app, open a AI system and an LLM model, and he just command you like that.
Participant
He
move
should be
to the
having some
recommendation and
control.
suggestion. Move to the recommendation and suggestion, participant.
So the best way is we can adopt the concept of innovation oversight approach. How we can provide an administrative guidance that administrative guidance that these are the qualification tests we can that human should have, that human should contribute for a for registering as a AI, for registering an invention under the AI regime. Second, we can make made second apart. First, we need to guidelines for a specific, so that we have time for our legislatives to make a proper codified law for inculcating AI is generated inventions. And third, the institutional capacity. The third step is institutional capacity, which means that we need to train a patent officers about how can we identify whether there is a concept of where there is a proper contribution by a human or not. So that as we have a procedural gap and we don't have a institutional capacity right now, so we need to to start by step to step analysis. First, we need a specific time guidelines, as we can, so we can direct ourselves for whether how to move towards this concept of innovation. Second, we need a solid ground, because because a law without solid grounds does not means anything. So we need a solid ground, and if we delay further, we might suffer. As according to Peter Gross, India should be the one that leads the world in innovation, not the one who falls, because the one who falls need to pay for using the things. Thank you.
Okay, you had talked about the AI generative inventions. So AI
Yes, and their
generative
patents.
inventions are allowed for the patentable in India or
No,
any
they are not.
elsewhere in the world.
No, the issue is that the only two types of patenting is allowed is where the complete contribution of a human, or second, where some minimalistic contribution by a human. It's not like that a complete product innovated by a AI model can be patented anywhere in the world right now. They have
Okay.
clear stand that a human is a person with a legal capacity to be an inventor. Same
See,
with the concept. That's why.
first and foremost criteria for being an inventor specifically is to being any natural being, means natural person is only allowed to be the inventor. Second criteria,
Yes.
the holder of the invention has to be like a human being. Like for example, if the inventor, let's say, uh, has co-authored or has invented jointly with artificial intelligence, but here the holder, like a person who has sponsored the invention is the holder, has to be the human being. So when we looked into the patent aspect throughout the world internationally, not only in India, the aspect is very clear. It has to be the human being. Now, when I looked into your topic states artificial intelligence generated inventions. So what do you mean to imply by that?
I want to imply that the AI that that the case of Davis. where an artificial intelligence, without any contribution from a human being, without any prompt or like that, he invented a beverage container model. Then in that case, who owns that patent? Because we don't have any provision for this, even in India or in whole world. So we need to specify ki those, they might be in less, they might be 5% out of 100%, where AI completely invents or something. But in that case also, who will be the owner of that thing? The question lies here. For that, I recommended
What are the
approaches
country
that
model? What are the country model you would assist?
I have assessed guidelines.
What are the
The
countries?
guidelines guidelines by US, UK, Europe, and Japan.
All right. All right. We can move ahead with the next participant. Thank you.
Thank you.
Next up, we have Deepak Kumar from Silver Oak Law College.
Sir, I am audible.
Yes, you are.
Okay.
Yes, participant, you can start your presentation.
Sir, slide is visible perfectly.
Yes, it's visible. You can start.
So thank you very much. Good morning, all jury members. So my topic is critical analysis of the registration and regulatory framework for essential derived variety under the PVP and FR Act 2001, legal gaps and practical challenges. So in this study, we generally analyze the two main objectives. Well, first is the analyze the legal framework governing the registration of the essential derived variety under the PVP and FR Act, and more focusing on the statutory and the regulatory framework nationally and internationally. And also, we also see the different practical challenges in implementation and enforcement of EDV provisions. And we have also some study through the questionnaire and the different respondents. So if we see the variety in context of India, the seed market, the seed market is increasing, and India market basically in 2024-2025 is 3.8 to 4.25 billion, and we are expecting that in 2030 it will be increased up to 5 to 7 billions. So it is due to the different technological innovations and acceptance of the consumers, the hybrid adoptions, high yielding varieties in case of different like rice, maize, cotton, and vegetables. And we are the fifth largest seed market. So if we discuss these things in context of the plant variety, because the plant variety are not the patentable items under the Patent Act, so it is excluded. So as per the Article 27.3 of the TRIPS is basically mentioned that if any member country exclude the patentability of the plants, animals, so they can exclude, but they must provide protection for plant through the patents or sui generis systems or a combination of both. So India adopted the sui generis systems in a form of protection of plant variety and farmer rights, which protect the rights of the breeders as well as the farmers' rights, and also registered and also recognize the different kind of varieties. Similarly, internationally, the other instruments which known as the Instrument Treaty on Plants and Resources, Food and Agriculture, in context of the cultivating varieties, also protect the farmer rights or the breeder rights internationally, and also support the food security. So how can we decide, how can we analyze that it is plant variety? So plant variety is a group of plants and a single botanical species which follow the distinct uniformity and stability guidelines. So if any combination of plants is distinguishable from other variety in a form of shape, size, color, and yield resistance, or the uniforms, or became stable for generation to generation, it's generally known as the plant varieties. Is also mentioned in section 2ZA. So, and it is basically the lowest rank of the, if we classify it in a form of the genus or a species. So it's the lowest known ranks, and it is also defined by the expression of the characteristics in a form of color, yield, resistance that you're looking for. So it should be remain uniform and stable. So different kind of categories are recognized in India, like the new variety, extant variety, farmer variety, or essential derived variety. So new variety are those variety which are not sold, or they have not filed application 1 year before, and they also follow the criteria of novelty, distinctness, uniformity, and stability. The another is the extant variety, which are already available in India in the domestications and under cultivation, and already notified under the Seed Act 1966. And the farmers variety, the name suggests, is already developed by the farmers. So essential derived variety are those variety which are derived from the extant variety, which are in the cultivation, but they have a specific advancement in specific characteristics. So they are basically in India is very limited. In case of genetically modified varieties, also covered in the essential derived variety. So if we see the duration, 18 years, trees and vines, other crops 15 years, extant variety and 15 years. So if we talk about the essential derived variety, so definition is very clear under section 23 that derived from the original variety. It should be distinct from the original variety by which it derives in a specific single characteristics or retain the basic feature from generation to generations. And these variety can be developed through the mutation or natural selection, through culture technology or gene modification or backcrossing methods. So if you see the data of plant variety production organization, we have only 14 varieties. What are the issue behind the only 40 varieties registered in this category? And all are varieties in genetically modified cottons. And these cotton tetraploid cotton and basically is by the private sectors. If you see the data, the most of the varieties, 14 variety in a case of tetraploid cottons, fiber crops, JK Agri Genetics or Nojividu, all are the member of private sector, not a single member from the public sectors. So what are the challenges for the IDB registration under PVP and FR Act 2000? Different kind of challenges. Some I have already mentioned here. Definition ambiguity, because in a definition is probably mentioned the essential characteristics. The essential characteristics, basically the degree of distinctness needed for differentiation from extant variety is unclear. So which extent, in which quantity, there are no matrix is there. And lack of clear genetic threshold level is also not specify precise molecular, which kind of molecular markers or genetic markers is used to determine the specific characters. So it's already uncertain. A dispute between breeders, because already you have developed a variety from existing variety. So there is a dispute between the original variety owner as well as the extant variety developers. So there is issues of benefit sharing and the complex just testing requirement for identification that is a new variety, so that you have to execute a test, distinctness, uniformity, and stability. So it's a very complex challenge because you have required a specific or uniform operating procedure to identify it is differ from the extant variety. And high cost and technical expertise, because you require the technical expertise and you have required the molecular genetics or molecular markers knowledge and different scientific knowledge. That's why cost is also involved and lack of
Participant,
awareness. Yes.
participant, you can move to the conclusions.
Yes, yes. So I have execute a questionnaire that what are the status of the awareness. So in 200 out of the 200 participants, 136 means 68% have an awareness gaps. 88% face technical barriers to understand about that. Lack of technical support limited, or 88% of capacity building, they have not the knowledge, they have not the infrastructure, and regulatory firm 54%. So they are the lack of awareness or technical supports, or they have not ever had ADV registration process. So what are the conclusion? So we have required the well precise or clear definition of the EDV in a PVP and FRX, and we can also include it from the international production of new variety of plant OPOV system, which already adopted by the European Unions. And we have also optimized or standardized operating procedure for testing for this type of variety, and we have to create a different a separate fair compensation model. And we also execute a awareness program between the different stakeholder breeders or farmers or the different universities, and we have provided a digital platform for the transparency, because if you file application, so what are the status, there any kind of prerequisition, any issues with the application, so these things would be included. So this is from my side, sir.
Okay, participant, when I looked into the digital derived protection variety, there are certain things which across the world, specifically, if you look and see the countries which has implemented UPOV, India is not the signatory of the UPOV, but there are
India,
the other.
yes, sir. India is not signatory of UPOB
Yes.
because in a previous version of UPOB, because there are some issues related to the farmer rights. So
Yes,
farmer
yes, yes.
cannot.
In
So,
order
so,
to
so that,
promote the farmer rights, India avoided to be the signatory of the UPOB because they were promoting the breeders' rights more rather than the
yes,
farmer rights. But when we looked right now, the digitization, UPAV is well digitized in all the countries where it has been implemented. They are having the international portal monitoring system. In one registration, it gets protected. uh, these are some of the things which we can definitely look into the UPAV convention countries which they have implemented properly, and we can implement in our PVP Act specifically with their proper amendments. See, for two things in India which we are presently in challenge. First is the registration. There are
yes,
very few registration specifically for the plant variety, and when we looked into the essentially derived variety, it is more fewer, like
yes,
very less. Now essentially derived variety, how we can increase up the registrations, by right, you well said that we have to come up with the awareness. But before going with the awareness, who will make the people aware? There has to be training professionals, trained professionals. So this
uh,
is one of the thing which you can include in your suggestions. Looked into some of the drafted research documents from UPAV, how they are coming up with the recommendations for present day suggestions and the problems they are being facing. You can look with the recent meeting datas, like what are the minutes of the meeting which they had conducted recently. It is all uploaded to public document available. You can look and see what are the challenges they are facing. We have to just consider those challenges with respect to our farmers, so which we'll be looking forward in the Indian context. That's
yes,
it.
sir. So one more thing is with the essential derived variety, because most of the varieties are genetically modified varieties. So with with genetically modified varieties have issues of governance system, and it's a different provisions, different kind of permission like GAC, RDAC, or different authorities you have required permission. So now recently the government of India through the site directed nucleus 1 2 categories also exempted from this genetically modified category. And recently in April, India released CRISPR Cas9 enables gene editing variety in this category. So I think as your suggestion, as well as some challenges with the developing of EDV, definitely this would be included, sir.
See, again, like when we looked into the exemption category, as you mentioned, that these are the varieties which has been excluded. In our previously, there are permissions which are required from various departments.
Yes,
Now,
sir.
one check is always required in Indian context whether the exemption will benefit the farmers, or the like it would be benefited by the breeders in a larger context, because these two are very contradicting factor. We cannot promote the farmers right and the breeders right altogether. If we promote the breeders right, definitely a farmers right would be violated to some extent. So these are the critical analytical part which is required to be highlighted in the research paper, like so that we can give a better suggestion to the government. So I will
Thank
suggest you to look to also consider in this aspect.
Okay, sir. Thank you. Thank you, sir.
Thank you.
Next, we have Shreya Shrija from School of Law, Nasi Munji Institute of Management Studies.
Visible and audible?
Yes, you are.
Okay, I'll just present my screen. Is the presentation visible?
Yes, it is.
Okay. In biologics, the real monopoly is not written in patents. It is embedded in knowledge that the law does not know how to touch. Good morning, everyone. I am Shreya Shrija, and today I will be presenting on the topic manufacturing know how as a barrier to biologic access in India, legal and ethical challenges. The central argument of my paper is simple. In pharmaceutical law, especially biologics, patent law works exactly as designed. yet still fails to deliver access. This failure does not arise from weak patent protection, but from something patent law was never built to regulate: manufacturing know how protected as trade secrets. For that, it is first important to discuss what manufacturing know how is. Now, it falls under the purview of trade secrets. In some simple terms, a trade secret is any valuable business information that a company keeps confidential to stay ahead of its competitors. Manufacturing know how is experience based knowledge that gives companies a competitive edge precisely because there isn't one written down. There's a Venn diagram here to help explain this whole phenomenon better. Now, to understand why compulsory licensing succeeds for small molecule drugs but falters for biologics, it is first essential to understand the science. This diagram over here differentiates between biologics and small molecule drugs. So, allow me to explain that. Now, on your right hand side, we have small molecule drugs. Each molecule has a fixed and exact chemical structure, which means that once the structure is disclosed in the patent, any manufacturer can reproduce the same molecule as a generic using standard chemical process. On the left hand side, we have biologics, which is completely different in nature. They are large complex molecules made using living cells. They are not defined by their final structure, but the process that they are made in. The same biologic can look slightly different depending on the cell line used, the growth conditions, and the critical quality attributes. This is why it's always said that the process is product when it comes to biologics. Moving on, Indian patent law is built on disclosure monopoly bargain, wherein this one discloses fully, enjoys exclusivity temporarily, and then allows public access. This assumption holds for small molecule drugs but collapses for biologics. Even after compulsory licensing, manufacturing know how remains legally protected as trade secret. Compulsory licensing solves legal monopoly but not the technological one. This brings us to the core legal dilemma that sits at the intersection of competition law and constitutional ethics. On one hand, when a dominant firm refuses to share essential manufacturing know how, such refusal may raise concerns under Section 4 of the Competition Act as an abuse of dominant position. On the other hand, compelling disclosure from them creates an equally serious problem. Trade secrets, they derive their value only by way of secrecy. Once it is disclosed, it is permanently lost as a competitive advantage. And especially when it comes to the biologic sector, this loss is especially severe because process efficiencies and quality control are what differentiates these firms in the market. Especially during public health emergencies, delayed access is essential. Delayed access to these essential biologics directly implicates the right to health enshrined under Article 21. The law, therefore, finds itself caught between protecting innovative incentives and fulfilling constitutional obligations to public health. Now, my paper does not argue for dismantling trade secret protection. Instead, it argues for a multifaceted intervention in a threefold manner. Number one, disclosure should only occur during formally notified public health emergencies and only to the extent strictly necessary for manufacturing. Number two, any transfer for manufacturing know how must include any sort of fair compensation, confidentiality obligations. And let's say that if a company is violating this whole compensation scheme or the rules that are there, there should be a standardized sanction on the basis of this. And lastly, instead of public disclosure, critical know how can be placed with regulators under controlled access, preserving secrecy while enabling access. Now, this preserves innovation incentives while preventing secrecy from becoming perpetual exclusivity. Biologics expose this huge gap between legal form and technological reality in contemporary medicine. And the solution lies not in weakening trade secrets, but in regulating their impact when public health is at stake. Thank you.
Okay, participant, your topic states the know-how, manufacturers know-how, and
Yes.
somehow you had related with the trade secret. Now, my
Yes.
question to you is, If the know-how is IP, intellectual property,
Yes.
then definitely all the intellectual properties, first and foremost criteria is public disclosure.
Yes.
And
Yes.
the reason behind public disclosure is IP is not the specifically private property. It's not a private property. It's a positive monopoly,
Yes.
but the property is being made for the benefit of the public. So if the
Definitely.
property is made for the benefit of the public, it is a property belongs to the public, but a positive monopoly belongs to you. It's not an individual property. That's what the
Absolutely.
IP is. Now when it comes to the trade secret,
Hmm.
the the concept is completely turned around, right? The IP right holder is having the trade secret until and unless the information is kept secret. Once the
Yes.
information is disclosed, it is no longer a trade secret.
Hmm.
It is no longer secret. So now my
Yes.
question to you, you are coming up with this thing that a know-how has to be like a trade secret, and also as well as a IP, how it can be within the intellectual property domain altogether.
Sir, so my entire point of this paper was this exact dilemma that you have just mentioned, that if we are protecting it as IP, then it's bound to be disclosed, then trade secrets will completely drive the company out of business. But the thing here is, I'm not trying to put a blanket solution to it. There can be a detailed way of, there can be a multi-layered way of going about this issue. So, as I also mentioned in my suggestions, what we can do is, here we can just make, first of all, come up with certain rules or regulations, so that especially when it comes to public health emergencies, like we have the concept of compulsory licensing, during public health emergencies there can be some rule or regulation which there should be like at least some provision which at least enables this manufacturing know-how to go to the company who is trying to come up with biosimilars. Secondly, if there should be somebody who is regulating this, so this the manufacturing know-how information, instead of going directly to the company,
Okay, are
it
you
can go.
are you only specifically talking about trade secret law, or you are talking about the IP as a whole?
I'm talking about trade secret and manufacturing know-how specifically when it comes to
There is no
biologics.
legislation for manufacturing know-how. First, try to understand the concept.
Yes.
If it is an IP, whether it would be a copyright or patent or trademark,
Yes.
these are the thing which it can be, right? If it
Yes.
is an
Yes.
IP. So if we consider, let's say it's a patent. For a
Hmm.
patent, there the company is getting a patents right, and the company is working with its business, right? Like
Yes.
it's a
Yes.
product, patented product.
Hmm.
Now the company, let's say, is manufacturing a certain medicine. If the medicine is patented, whenever in public emergency arises, the company definitely will get lot of objections, and the government has to provide it with the compulsory license, because
Yes.
altogether everything is available.
Yes.
Now the product which the company do in the business, that is the patented product, it's already being published, all the process, because
Yes.
prior to getting a patent, the thing has to be in the public domain. It has to
Absolutely.
be in the patent journal. So
Yeah.
everything is published. The company is working because the company is the has the right, legal right to work on this. Now,
Yes.
where is the question that the company cannot work after disclosure of the information? There is no question for it.
Sir, what I'm trying to argue here is compulsory licensing happens and the information that has been disclosed, it goes to the companies. Now, there is certain knowledge which comes by way of experience or by way of trial and error method, which is not disclosed. And reverse engineering the same will take, and there's research on this, reverse engineering the same will take around 8 to 10 years, which if a company is disclosing this particular, so, like compulsory licensing, if they are
There,
disclosing this
there is
particular.
no provisions. There is no provisions where it is mentioned that a experience has to be shared. Even
Yes,
in
yes, sir.
even in
Absolutely.
even in multifaceted, like whatever suggestions you had made in multifaceted layered disclosure has to be made, there is no provision. First and foremost thing, personal experience doesn't count as a property. It's an
Yes.
mere moral right of an individual, and moral right can't be shared as per the intellectual properties concerned in any
Yes.
of the IPs. So we cannot take up these recommendations, like specifically on the ground of this. I will tell you, you should look into some of the well documented aspect of this topic for the technology transfer, and to frame with the precise suggestions and recommendations in an appropriate manner.
Sure, sir. Sure.
All right, yeah, thank you. We can move
Thank
with
you.
the next participant.
Next up, we have Aparna MP from Maharashtra National Law University.
Yes, sir. Am I audible?
Yes, you are audible and visible.
Okay, let me share my screen, sir. Sir, is my screen visible?
It's not visible as of now.
Okay. The sharing option is like disabled here. I don't know why.
Participant, kindly keep your screen loaded prior to the
Yeah, it
presentation.
is opened, but still the share option is like disabled.
If it is taking time, we will move with the next participant. We can call you later. The host, we can move with the next.
Okay, sir.
Sure, sir. Next up, we have Samyukt V from Sastra Deemed University.
Okay, Samyukta, are you present? You are not visible and audible. No response.
Okay, so we can move to the next. Then we have Himanshi Singh Thakur from Hidayatullah National Law University.
Am I audible and visible?
Yes, you are.
Okay, let me just share this slide quickly.
Your slides are already visible. You can
Oh,
start with your presentation.
okay, sir. Okay. Good morning to one and all present here. Today I'm here to present on the title of my paper, Rethinking IP Capacity Building Through Commercial Marks, a Colombian case study and lessons for India. So, especially, basically with my paper, I have focused on three important pillars. First is how can we move beyond just legislative harmonization of hard IP norms towards more community driven soft IP tools, so as to we can um, the focus has always been on to just compliance. How can we actually go beyond compliance and beyond adoption of laws to actually work them on the ground and bring benefits to the community as actually sought by IPRs? Then I am doing this through Indian and Colombian experiences around geographical indications and what are the impediments. And my special focus is on the Colombian case study as to how they are using collective marks to tackle the impediments and ultimately build capacities of its artisan communities. And what can India learn from that Colombian initiative? So the main focus of my paper is how capacity building in IP can be facilitated. So let me start by focusing on the last year's World Trade Organization's high level dialogue commemorating 30 years of TRIPS, and wherein it was. Wherein it was discussed as to how we can further fine tune trips and what are the issues that the global south continues to face. And one of the important points that was focused on the future IP needs. And the Brazilian ambassador, if I'm correct, focused on the systemic capacity deficits. And since I'm focusing on the gaps in implementation, that is what the ambassador also focused upon, that this systematic capacity deficits, including resource constraints, administrative incapacities, legal and judicial deficiencies, lack of IP literacy, how these factors sort of in create an obstacle in implementation of IPRs and realizing its true objectives of empowerment of creators, particularly artisan communities. So let us see how what has been Indian experience around GI. So Geographical Indications of Goods Registration and Protection Act of 1999 is a sui generis framework, and it largely is a good law which focuses upon the registration and how to enforce GIs and how to protect the local communities and how to develop these local heritage products into commercial assets. So that has been, the law has been largely functional and operational. The primary issue came with has been experienced with regard to the implementation. And if you analyze these issues regarding implementations, they somehow end up uh, relating to the capacity deficits which can be seen at the different levels. For example, so I have enumerated how capacity deficits are visible. So GI registration sometimes, or most of the times, they just end up being symbolic endpoints, because there is no post registration measures, and there's a lack of marketing and branding and all those issues. So somehow GI registration sometimes work as endpoints. Then there are institutional gaps, because there is lack of decentralized support to the community, the organizations, and the associations of the artisans. There is also lack of formal organizational structure around how to organize these artisan groups. Then there are also issues related to quality control, as to once the GI has been given, sometimes it so happens, as we'll see in Banarasi saris case also, that counterfeit comes up. There is no quality inspection. Sometimes it so happens that
Participants move to the recommendation and suggestion.
yes, sure, sir. But sir, before that, let me just quickly focus on the Colombian strategy, because this is the core part of my paper as to how they are dealing with it. So they also faced with similar issues, and they have come up with this idea that despite their denominations of origin, that is how Colombia protects GI. So despite their DOs, they also started prioritizing collective marks and certification marks, and specifically they focused on institutional support. So they established a body called Artisans of Colombia, and it is specifically dedicated to provide technical assistance, legal aid, and training to the artisans. And also, as a novel measure, they also reduce their registration costs through preferential tariff regime. Then they also work towards market integration. This Colombia Artisans of Colombia body organizes national craft fairs. It also integrates members with directly export chains. There's also Superintendency of Industry and Commerce, this body which helps, which is basically national IP body of Colombia, and they help small producers to access information and understand the procedure. And there can be their efforts can be analyzed in the terms of success stories, that they have experienced rise of nostalgia products which are basically agricultural goods, foods, and beverages, including handicrafts and stuff. So they have also experienced that the exports have risen, and their particularly their eco fibers of fique, of curity, which is known as fique de curity. This is a collective mark, and this also strengthened the capacities of the weavers of curity village of the Santander region. So what can India learn effectively from this Colombian strategy? So what we can do is that we can, instead of giving specific products to specific IP protection to specific products, we can also inculcate sequential protection, or because there is an interplay. So first the collective marks can be given, then GI can be registered, or the existing GI registrations, if they are facing any sort of commercial impediment, so they can be given collective marks, so as to enable them to effect their to sell their product or to export their product effectively and to integrate with the international market. Also, there has to be a cluster recognition. There has to be formal documentation of both formal and informal artisan clusters. The government has to create sort of institutional support, like agencies like NABARD and TriFed. These bodies can help with their commercial operationalizations. Then of course there can be tech integration, as in we can create an online database enlisting the products and the related artisan organizations. We can also use QR based traceability, for in order for the consumers to be able to trace back to the weavers and their products. So, as a concluding remark, if I apply a Amartya Sen's capability approach, IP rights can have only meaning if the capacities have the capacity to use them, and capacity can be regarded as a means to the end of freedom. And freedom not just to express oneself culturally, but also to conserve civilizational heritage and to derive livelihood out of such conservation. Thank you.
Okay, so participant, you had mentioned about the Colombian strategy. How much it is implementable in India? Just give a crisp answer, short.
Yes, sir. We can, first of all, we can build such framework within the agencies, particularly TriFed, because TriFed is involved in commercial selling of GI products and the heritage products. So we can strengthen our institutional capacity, our NABARD and our agencies. Also, regarding collective marks, what we can do is that, because we already have a lot of GI tag products, so the products which are not doing well commercially, or the benefits are not being channelized to the weaver or the artisan communities, we can have an impact study as to what happened as the artisans of Colombia's body do there. And we can also give them collective marks and organize frequent fairs, and we can have trade, like the way we have trade expo, we can have handicraft and art and culture expo of the sorts. So we can pick these measures from the artisans of Colombia.
All right. Thank you.
Thank you, sir.
So before moving ahead with the next participant, a small note to all the participants. Since we are exceeding time, we will be not providing suggestions or recommendation to each and every participants. We will come to the conclusions. After that only, I will come up with the brief suggestions if it is required. Yeah, host, we can move at the next.
Okay, next we have Aparna MP.
Sir, I hope I am audible.
Yes, you're audible and visible, but your PPT is not visible.
Yes, sir, I am just sharing it. Yes, sir. Is it visible now?
Yes, it's visible.
Okay. So, good morning, sir. My name is Aparna MP. I'm from MNLU, Maharashtra National Law University. So, I'm presenting the paper titled Artificial Intelligence in the Cosmetic Industry, Legal Challenges in Intellectual Property and Data Protection. So, this paper examines how AI-driven cosmetic innovation challenges traditional concepts of authorship, inventorship, ownership, and data privacy, particularly across different legal systems. So, coming to the background of AI in cosmetics, the cosmetic industry has undergone a major technological shift with the adoption of artificial intelligence. Traditionally, the cosmetic formulation relied on human expertise and trial and error method. So, also laboratory testing and all. So, here AI has replaced this with the predictive modeling, virtual testing, and personalized skincare recommendations. So, these development has improved the efficiency and complied with ethical mandates, such as the European Union's ban on animal testing. But they also raise serious legal questions. So, my core problem addressed in this paper is that existing intellectual property laws are human centric. While AI system increasingly generate outputs autonomously, this creates uncertainty regarding who owns AI generated cosmetics designs or formulations, how such outputs can be protected, and how transparency obligations can be balanced with trade secret protection. So these issues are further complicated by cross-jurisdictional inconsistencies. So coming to the objectives and research questions, my research has four main objectives. That is, first, to examine how AI challenges traditional ideas of authorship and inventorship. Second, to assess whether copyright, patent, and trade secrets laws adequately protect AI-generated cosmetic innovations. Third, to compare approaches across the EU, like European Union, United States, China, and India. And finally, to identify data protection challenges in AI-based personalization. So the methodology that I have adopted is a doctrinal and comparative legal methodology. It analyzes statutory frameworks such as the GDPR, the Indian Copyright Act, and the Patent Acts, along with landmark judicial decisions including Taylor versus Permuter and Anderson versus Stability AI and Lee versus Liu. So the goal is legal interpretation and policy evaluation rather than empirical measurement. So the copyright challenges are copyright law is founded on the requirement of human authorship and originality. In the United States, the position is clear that is, purely AI generated works are not copyrightable, as confirmed in the case of Taylor versus Permuter. In contrast, jurisdictions like UK and China show limited flexibility where human involvement is identifiable. So this creates uncertainty for AI generated cosmetic designs, packaging, and marketing content. So coming to the patent and trade secret issues, patent law presents a similar challenge. That is, although AI contributes significantly to cosmetic formulation and innovation, inventorship is legally restricted to natural persons. So as a result, companies increasingly rely on trade secret protection to safeguard AI algorithms, training data, and formulations. However, excessive secrecy can conflict with regulatory transparency and consumer accountability. So, regarding data protection and privacy, AI-driven personalization depends on sensitive data such as skin images and biometric indicators. So under the GDPR, that is General Data Protection Regulation, consumers have a right to transparency and explanations in the automated decision making. So in the US, the CCPA, that is California Consumer Privacy Act, emphasizes data access and deletions, while India's Digital Personal Data Protection Act focuses on consent and purpose limitation. So these frameworks create complaints and obligations that directly affect AI-based cosmetic service. So my key findings and implications is like AI-generated cosmetic innovations currently fall into a legal gray zone. So divergent national approaches increase litigation and complaints risk for cosmetic companies operating globally. At the same time, firms that proactively integrate legal complaints and ethical AI governance may gain a competitive advantage. So, to conclude, AI has immense potential to transform the cosmetic industry, but legal frameworks must evolve accordingly. The law should recognize human in loop contributions, like clarifying ownership of AI generated outputs and balance trade secret with transparency. International harmonization and ethical AI governance are essential to ensure innovation, consumer trust, and sustainable growth. So that's it. Thank you.
Yeah, there is no question for you. Thank you.
Thank you so much, sir.
Next, we have Vibhan Soni from Christ University.
Sir, am I audible?
Yes, you are audible and visible. Your PPT is not visible.
Sir, am I audible?
Yes, you are audible and visible. Your PPT is not visible. Participant, your PPT is not visible.
Hello. Sir, am I audible?
You are audible, but your PPT is not visible. You are perfectly audible, participant. You are perfectly audible, participant.
Am I audible?
Yes, you are audible. Yes, you are audible.
Sir, am I audible?
Host, I believe the participant is facing some network issue.
Yes, sir. I believe the same. Should I call the next person and like we can have him after he's done?
Yes, yes, you can go with the next one.
Okay. Next we have Suraj Vigneshwar from Wells School of Law.
Good morning, sir. Can you hear me?
Yes,
Yes, you are audible.
Yes, sir. Now I'm sharing my PPT. Sir, is my presentation visible?
Yes,
yes,
yes, it is.
you can start your presentation.
Good morning, everyone. I'm Suraj Vigneshwar from Wales University, and I'm going to present on patentability of AI-generated invention. In general, patent is the IPR given to the person who creates or invents something using his intellect, which is unique and non-obvious. On the other hand, AI is being evolved right now and capable of generating inventions on its own without any human invention. The thing is that non-obvious things to human can be obvious to AI, artificial intelligence. Uh, the purpose of choosing this topic is to analyze the patentability of AI-generated inventions and how they are treated under existing
Participant,
patent.
no need to explain the research objective. You can move with the main paper area.
Okay, sir. Uh, Internationally speaking, major countries like US, UK, Europe, and also India, though they never mentioned only human can get inventorship and patent expressly, they have mentioned it impliedly, like mentioning as natural person, which automatically rejects missions like AI to get inventorship. This can be explained in the Dabas case, where Dabas is an artificial intelligence created by Dr. Stephen Thaler, which is capable of inventing things without any human intervention. The Dabas made two inventions in which Dr. Thaler files patent mentioning Dabas as an inventor. Most of the countries around the world rejected it, except Australia and South Africa. Then Australia also rejected it, but South Africa didn't because they still don't have any proper statute for regarding patent, and that's why they encourage more patent filing as possible for their own development. Uh, Sorry, sir. We all know that at current era is focusing on AI technology, but due to lack of proper statutes for them, create uncertainty for such companies which are investing heavily on AI or not to invest on the R&D, that means research and development of the AI technology. And if the prompt provider considered as an inventor without any inventive contribution, dilutes the base of patent standards. In order to address these challenges, we have to make some changes in the patent law, like recognizing human-assisted AI inventions with full disclosure of AI involvement, and give sui generis protection for AI-generated inventions, and must scope up globally through WIPO. Uh, though AI generated invention challenges the base of patent law, it still remains human centric. But for economic growth and innovation, legal frameworks to be made which should balance patent law with technological development like artificial intelligence. Thank you all.
Okay. Thank you. We can move ahead with the next participant.
Thank you, sir.
Next up, we have Maitri Shelb Patel from School of Doctoral Research and Innovation, GLS University.
Visible?
Yes, you are.
Okay, now I'll present my PPT. Is my PPT visible?
Yes, it
Yes,
is.
you can
Okay,
present.
okay. Fine, fine. So as can be seen that our title is Copyright Sabotage, AI-driven targeted dataset poisoning in creative models. Basically, this paper here is to put forth the point that the most dangerous copyright threats in AI era is not the ones that are appearing as copyright infringement explicitly, but are the most dangerous ones that are not even visible at the training stage itself. So we have examined the a unique concept of targeted dataset poisoning in the context of copyright sabotage, which actually hampers the creativity of the creators as well as distorts the attribution and even triggers such copyright harms that are very, very difficult to trace. Now, the central claim here is that copyright law remains structurally blind to such training phase sabotage, which creates a regulatory vacuum that are exploited very much nowadays. Moving on, now coming to the context and background of the paper, as can be seen that there's a rise of generative AI which now produces art, music, literature, even design at scale, and it learns from the vast data sets which contain copyrighted works too. Now these data sets shape the attribution, originality, and even market value, but yet remain largely opaque and legally insignificant. Now, as creative decision making has shifted from human authors to algorithms, control over training data effectively becomes control over the culture, which has raised urgent copyright and governance concerns. Now, moving on to the problem statement that has been focused here is that the targeted data set poisoning when it comes to copyright sabotage is the very, very emerging threat that we are not able to see the invisible copying infringement that occurs at the data set stage itself. Now, why it matters? It matters because this suppresses the creator's creativity as well as the quality of innovations. It distorts the attribution and even the unique style lineage that is very, very much unique to each and every creator itself. It also undermines the copyright ownership even without visible copying. So there's a legal gap which copyright law lacks tools to address such training stage harms. Moving on, the research gap and objectives. Now, the research gaps that have been kept in mind here are is that present copyright law focuses on unauthorized reproduction and derivative works which are visible. It ignores the dataset integrity portion and training manipulation, which are very, very invisible forms of copyright infringement. Based on that, there are three objectives. That this paper reframes the dataset poisoning concept as copyright sabotage. It also examines the legal, ethical, as well as the cyber security dimension that needs
Participant,
to
you
be
can move to
considered.
the challenges. Participant, you can move to the challenges and its
Fine, sir.
recommendation.
Fine, sir. Sure. So the challenges are the types of dataset poisoning. There are four dataset poisoning. First is the attribution poisoning, which is about false association of styles and authors with the copyrighted works that in the training data phase, the algorithm absorbs and actually presents in a wrong way. Second is the style suppression. Each creator has its own unique style, but there's an erosion of specific artistic identities that creates to so many legal issues relating to styles, creators innovation, creator styles and everything. Third is market deformation, which is caused because of mimicking competitor styles. And fourth is the quality degradation. Now, the main challenge, the copyright law at its doctrinal failure. Now, why traditional copyright fails? It's because it mainly focuses on copying that is visible, and it is substantially based on the substantial similarity. Second, the dataset poisoning causes that systemic harm even without direct infringement, as I have mentioned at the algorithmic stage itself. Now, the main double trouble is that there's a, uh debate between fair use and fair dealing abuse, and as a conclusion, that there's a need for recognition of copyright sabotage in context of dataset poisoning. Now coming on to comparative and global perspectives, I have taken United States, European Union, and India, where United States actually focuses on fair use dominance, and there's no doctrine for training face sabotage yet. Even though European Union has the AI Act 2024, it still focuses on bias, but not the dataset integrity, which is the need of the hour. When it comes to India, there's still no explicit AI training regulations. DPTP Act 2023 is still irrelevant to such copyrighted datasets. So, as a result, there is a global regulatory vacuum. Coming on to the most important, another segment is liability ethics and governance, where ethical dimensions need to be considered very carefully where there's violation of moral
Participant,
rights.
you can move to the suggestions and recommendation.
So the key takeaways, so the key takeaways here are dataset poisoning is a paradigm shifting copyright harm which requires recognition as algorithmic sabotage in the age of AI. Existing copyright doctrines needs pertinent attention for they are inadequate to deal with this. Policy recommendations, there's a need for recognition in training phase harm in copyright law, and there's a need for integration in IP norms into AI governance. Thank you and have a nice day. That's all for my presentation.
Okay, thank you. We can move ahead to the next.
Next, we have Vibhansh Soni and Navodita.
May I
Audible?
leave, sir?
Yes, Maitri, you can leave.
Sir, am I audible?
Yes, you are.
Okay. So is my PPT visible over there?
Yes, your PPT is visible
Okay.
as well.
Good morning, each and everyone present over there. My name is Vibhan Soni. I'm author of this paper titled Trademark Rights in Cyberspace, an Analysis of Domain Name Dispute Resolution Mechanism and Online Enforcement. This slide that is showing in front of you, this remarks this that the central theme and the scope of this research paper, the title itself reflects the growing convergence between trademark law and cyberspace, highlighting how the internet has fundamentally altered the way trademarks are used, protected, and enforced. Traditionally, trademarks operated within physical marketplaces and were governed by territorial legal systems. However, with the rise of digital compliance, trademark now exists predominantly in cyberspace where domain name plays a crucial role. Now presenting the introduction of my PowerPoint presentation, which remarks the new challenges in the trademark protections. The internet has radically transformed the trademark protection by shifting commercial activity from physical marketplace to digital platforms. In the traditional model, consumers encountered trademarks on product packaging, storefronts, advertisements, and physical locations. Today, however, the primary interaction between consumers and brand takes place online, particularly through websites and digital services. The traditional trademark regimes are based upon the territorial jurisdiction and national registration systems. These frameworks struggle to regulate conflicts arising from global online use, where a single domain name can be accessed from anywhere in the world. The third slide shown is the borderless internet versus territorial law. This slide addresses the fundamental conflict at the heart of trademark dispute in cyberspace. Trademark law is inherently territorial. This means that same trademark can lawfully exist in different countries or market segments, provided there is no likelihood of consumer confusion within the same jurisdiction. The research explains that the structural mismatch has forced the development of new legal approaches. These approaches attempts to balance the right of trademark disputes holders, the legitimate interest of domain name registrants, and the broader public interest in maintaining a free, open, and competitive internet. This tension underpins all subsequent discussions in the paper. My fourth slide refers to the domain's name, that is technical routing and the commercial identifier. Basically, the technical perspective, domain name are part of the domain name system, which translates human readable text into a numeral internet protocol addresses used by computers to locate resources on the internet. This transaction functions make the internet accessible and user friendly, allowing users to navigate web without memorizing the numeral codes. Uh, Now we will talk about the commercial value as mentioned above. Beyond their technical role, domain names serve as the commercial identifier. These functions like digital shop address or trade names guiding consumers directly to businesses and services. Consumers often associate a domain name with brand reputation, authenticity, and reliability. The hierarchical structure is the domain name system is hierarchical, consisting of top level domains, second level domain, and subdomains. Each level carries different degree of legal and commercial importance. Traditional top level domains are .com that are being seen have historically associated with the credibility and commercial legitimacy. My fifth slide is the history of domain name dispute, that is cyber squatting. The commercialization of the internet led to the emergence of cyber squatting, one of the earliest and the most pronounced form of domain name abuse. Cyber squatter registered domain name identical or similar to established trademark with the intention of exploiting the brand goodwill. These registrations are often made to resell names as inflated prices, divert consumer traffic, or extract ransom-like amount from trademark owners. Early domain registration systems operated on a first come first served basis without verifying the trademark rights. As the
Participant
research highlights, the court initially
participant
attempted to resolve these disputes using traditional trademark infringement policy and passing off principles, but however, litigation proved inefficient due to jurisdictional complexities, high cost, and the increasing number of disputes, highlighting the need for alternative residual mechanism. Now we will discuss about the cyber parasites, which plays an active role in sophisticated form of domain abuse. Unlike cyber squatters who merely hold domain names, cyber parasites actively use infringement domains to generate revenue. This may involve redirecting users to advertise pages, promote competition products, and monetizing the consumer confusion. Now, the seventh slide is the UDPR. The full form of UDPR is the Uniform Domain Name Dispute Resolution Policy. The UDPR was introduced in 1999 to address the growing inadequacy of traditional courts in resolving domain name disputes. It was developed following extensive contribution conducted by the World Intellectual Property Organization, that is WIPO, and adopted by the International Corporation for Assigned Names and Numbers. The policy applies mandatorily to all major generic top level domains and is incorporated into domain registration agreements. The research explains that the UDPR provides a streamlined international alternative to litigation, allowing the trademark owners to challenge bad faith registration regardless of the registrant location. Now, the criticism and the biases that are being conducted upon the UDPR are as follows. The UDPR remedies are limited to cancellation or transfer of domain names with no provision for monetary damages. Despite these limitations, the policy has been criticized for engaging in aggressive brand enforcement strategies that may suppress the legitimate online activity. The the jurisdictional complexities and the future projections that we will discuss in future is the courts have experimented with tests based on website interactivity, but these approaches remains inconsistent. Legislative measures such as anti-cyber squatting consumer protection act allow in ram actions against domain name, partially addressing jurisdictional gaps. This research also highlights how different trademark standards across jurisdictions complicate enforcement.
participant you are exceeding
Emerging
time.
technologies such as blockchain based domains and the metaverse present new challenges that existing legal frameworks are ill equipped. Now, my last slide is the conclusion, that is balancing rights in the digital age. The conclusion slide emphasizes that while mechanisms like UDPR have been effective in combating the cyber squatting unit, they also have contributed to an expansion of trademark rights beyond their original consumer protection purposes. Uh, Thank you so much.
Okay, thank you. Host, we can move at the next.
Next, we have Ishpreet Singh from Himachal Pradesh National Law University. I think so. Ishpreet is not there. Next we have Dr. Pradnya Pahurakar from New Law College.
Thank you. I will just share my screen. Mm, yes.
Yes, participant, your screen is visible. You can
Okay,
start.
thank you so much. I hope my voice is audible.
Yes, you are
Yeah,
audible and visible.
yeah, thank you so much. So this is Dr. Pradnya Pahulki from New Law College, Mahi. My topic is AI and copyright, redefining copyright boundaries on authorship, ownership, and infringement. Uh, so, so as we all know that creative works has always been the human domain, and AI, with the rise of AI, artificial intelligence, the creative works are predominated, and thus it challenges the traditional legal principles of the copyright principles that we are having today. So understanding the artificial intelligence, I would just like to know mention here about Niti Aayog in India, which says that AI is a constellation of technologies that enables machines to act with higher levels of intelligence, which evaluate the human capabilities. So this basically challenges the human intelligence and the human creative works. Whereas WIPO also mentions that AI is a discipline of computer science which carry out various tasks with or without human intervention. So here we can, with regard to these two particular definitions, we can understand by making our policy provisions under that. Now, I would like to also mention that we already have copyright framework which is incompatible with TRIPS because we are a part of it. And thus we have in India Copyright Act 1957, which basically emphasizes on human authorship and originality for all the creative works that it is protecting. Now, as per if I talk about my paper basically discusses two main things, focusing on the policy framework to develop the policy framework. First is copyrightable of AI generated work, which simply means that whether the AI generated works, creative works, can be copyrighted or not. Second is that the use of copyrighted content of AI training, which specifically mentions that whether the AI models which are using the data sets to train the models, which includes all the original work, copyrighted work, uncopyrighted work, or any other works, whether the output of that particular work should be considered as a copyrighted material or not, and what should be the policy framework with regard to it. In relation to all of this, first we have to understand the legal gaps that we have, especially in India. We do not have an explicit provisions for AI generated works, and that is the major setback that we have. If you understand that India is hugely invested in AI, up to $17 billion, and the mode we are in the full mode of development of AI related things and activities. Therefore, it is very important for India to explicitly have statutory provisions if you want to protect the creators, the developers of AI, and also the copyrighted human authors. Um, or future authors rather, future authors of under the AI, under the copyright. Now, the because of not having a statutory provision, it creates an uncertainty for the creators and AI developers. Here I would like to mention about the Ministry of Electronics and Information Technology in India has issued certain policies under the IT Rules 2021, which basically mentions about obligations, practical implementations, mechanisms, particularly regarding the content labeling. And under that, we have seen that deepfake contents, deepfake videos, and other videos which are AI generated should mention it, that these are AI generated. The liability assessment needs also has been mentioned, data harvesting practice and enforcement procedure. If we study this, we understand that how the liability should be imposed in case we are incorporating AI generated creative content under the copyright. Here in my next slide, I've tried to mention about the issues basically. So here are two things: AI training data sets, which the AI models uses the data in order to incorporate the material, creative content, and to produce a creative content. Whether it causes an infringement or not, whether it should be considered as an infringement or not. So first is that the use of copyrighted data sets. When the AI is training its model and it is using the AI the copyrighted data sets, that basically causes an infringement of the material which has been copyrighted by the because of the human creativity. Another discussion here we should have with regard to is that the fair dealing. If in case AI creates a output, creative content which is fair enough and it can be copyrighted, whether in that case we should consider it or not. So here we have numerous precedent, but I would like to just mention this particular precedent, which is not a precedent, but it is a pending litigation. ANI Media versus OpenAI, where the traditional copyright laws have been in loggerhead with the, of course, dynamic functionality of AI machine, which is using this particular thing. And the issues framed here, I would just like to mention here it. The issues framed by the court are that whether the plaintiff's copyrighted data in order to generate response for its users, whether it amounts to infringement, whether the defendant's use of plaintiff's copyrighted data qualifies fair use. And the third one is that the courts in India have the jurisdiction to entertain present lawsuits considering the servers of the defendants, which are located in United States of America. If this particular case is decided, the two things we will have the clarity on. First is the usage of fair use doctrine. Another is by the AI models. Second is on cross-border issues that basically needs to be addressed only after the discussion with the stakeholders, which I completely think of. Here, on the next slide, I will just give a comparative.
Participant, you can move to the conclusion. Time is already up.
All right, all right. Thank you. So the policy recommendation which I have given is that we have to recognize AI-assisted work with human inputs only, and the AI-generated work should be copyrightable. Here, the original content should be considered only with human intervention, and they should be given the AI-generated creative work should be given the copyright because it is very important to develop it with the technology. As for the European Parliament, I would suggest that this is just a suggestion that the AI should be given the identity of electronic persons or autonomous robots that would erase the conflict between the human created creative works and the AI generated creative works. They should not be recognized as citizen because that is not the purpose of causing conflict between the humans and AI. Mandatorily, AI content should be labeled, even if it is not copyrighted. AI training data, including transparency obligations and fair dealing boundaries, are essential and should be mentioned. Derivative works, this particular provision should be included, which is not an Indian provision, but in India we have adaptation provisions under copyright. But derivative work should be included with regard to AI generated works, and transient storage of copyrighted expression during training of Gen AI models at the same is to be considered an infringement until the final product creates a similar deceptive or similar content copyrighted. So basically here we have to understand the context of the output that AI generated creative works creates. Then international cooperation and continuous stakeholder consultation should be guided for the future reforms, of course, and clear liability rules should be mentioned in order to, allowing the developers and creators of AI companies. So I would like to conclude here is that the AI challenges traditional copyright laws, so that is why the balanced legal reform is essential only after the discussion. I would just like to thank you for allowing me to wrap up my
Okay.
presentation.
So participant, in many places you had mentioned that
Yeah.
AI should be like having the copyright of any content which is being generated by it.
Yes.
So coming to this notion, specifically the ownership, when what is the purpose of ownership? The purpose of
So
ownership is to, like, I'm just giving you some clarification regarding your paper where there should be changes. It's not a question. It is just suggestion. The purpose of ownership is to claim the economic benefit out of it. So this is the first point where the AI lacks. Like AI, a non-human person and non-natural person, what the person would be doing with the economic benefit? There is no concern for an economic benefit for an AI. This is the first object. Second thing, for an AI, there we cannot be provided moral rights, because moral rights, when you talk about the
yes.
moral rights, it belongs to an individual. That's an living emotion. Like the person who is having an emotion can only have the moral right. Second thing. Now, third aspects of the artificial intelligence is the legal right. Legal right means the personality right, which we looked into
We
the
are not.
jurisprudential aspects. So these three aspects the AI lacks, and it is time and
Uh,
again even the courts across the world, even the US Supreme Court
yes.
or the
This
UKC
needs to be
Court.
discussed, sir, but here, if you don't mind, if I add one more point to your ownership point, if it is okay with you.
Yes, yes, yes.
Yeah, just basically the idea which I was mentioning with regard to the ownership is that when an AI generated work, creative work, when we talk about it, there are 2 points into it. First, it is with the human intervention, and second is without human intervention. So my suggestion or my topic suggests that, or my research suggests that. First is that the AI generated with the assisted human intervention should be copyrightable only. Firstly. Second thing is that if we are considering an AI generated work which is without human intervention, but it is original, then we have to think over this particular provision as well, because it is very important for us to go ahead with the technology. That is the one thing. Second thing, with regard to the ownership, when we are talking about the ownership, for example, if I am a company and I am creating an AI generated creative content, and that creative content is basically, of course we know we cannot give them the legal rights or moral rights because they do not have that emotions, and that is why it is very important that when we are considering them as electronic or autonomous body, then in that particular case we can give them a limited scope of rights, okay, which would give the right of ownership to the company, and we can make the company liable. Here we can take both the provisions which has been explicitly mentioned by China and UK, where they are not very clear, but where we can take up from there, that we can utilize this kind of framework in order to impose liability, because it is very important that we cannot avoid AI generated works. We cannot do that. Otherwise, it would create more chaos. And by giving them right, which I think UAE has given them the citizenship.
All
Uh,
right, participant. There is a note I want to like give you specifically on this particular portion of your study. So AI, artificial intelligence, when we looked into a broader aspect, like as you mentioned, that it needs protection. If the content is original, which is being generated, it needs protection. Here, the aspect is not our economy, like economic context is completely skipped. We have to skip this. We have to just look into the protection, that
yes,
the content which is being generated, it is protection must be provided to that particular article. I'm terming it an article. Now for this you can look into, there is a concept called creative commons. Creative Commons, it's well recognized in the Western countries, where all the articles, let it be the artwork or the other thing, literary work, here the publicly content, what can be shared to the public, what can be not shared, what can be shared in all together, or what can be shared in a modified version, it's clearly mentioned. You can look into the Creative Commons and make your suggestions likewise, if we can incorporate all those on the international scale along with the Indian standards.
Yes, yes, yes. Sure,
Yes,
sir. Thank you so much.
thank you.
Shall I leave?
Yes, you can. Yeah,
Thank you,
host, we
thank
can move
you.
with the next.
Next, we have Samyukta from Sastra Deemed University.
Good morning, sir.
Yes, kindly share your screen.
Yes, sir, we will sharing the screen. One second, sir. Sorry for the delay. Screen.
Okay, your screen is visible, you can start.
Sir,
Yeah, your screen is visible, you can start.
sir, is the screen visible? Shall I start?
Yes.
Good morning, I'm Samyuktavi and this is my co-author Devarajan B from Sastra Deemed University, Tanjavur. We are going to present our paper titled Rethinking Authorship in the Age of Generative AI, Legal Challenges and the Path Forward. Imagine this, a Hong Kong singer, Wang Wang, releases a song using an AI generated clone of his younger voice. He is singing with himself, or is he? This song is beautiful, commercially successful, and yet who owns it? Is it his, or is it AI's, or is it anyone at all? This is not fiction. This is happening right now, and our copyright laws built on era of pen, paper, and human creativity are struggling to answer this fundamental question. When human and AI collaborate to create, who is the author? Today, we will walk you through this challenge and present a solution. Let me show you the fragmentation across the world. Courts are answering differently. In the United States, the Copyright Office has taken a hard line. In the landmark case of Taylor versus Perlmutter, an AI system called GIPC tried to register its own creative work as the author. But the US court held that AI generated work created autonomously are not subjected to copyright protection. The work goes straight to the public domain. The European Union also took the similar stance. They demand human intellectual efforts, human creative freedom. A work is protected only if it bears the personality and creative choices of human author. However, in the United Kingdom, it was not the case. Under the Copyright Design and Patent Act, Section 9, Clause 3, they recognize computer generated works. The human who organized the work, who set parameters, selected outputs, integrated everything, that big person becomes the author. And in India, we have no AI specific law. But our courts, in cases like Eastern Book Company versus DB Modak, has given us the flexibility. They say that authorship attached to whoever exercise creative control. So, the same AI generated artwork is protected in the UK, unprotected in the US, and conditionally protected in India. So, this is a chaos. Creators don't know where to register. Jurisdiction suffers from forum shopping, where creators' resistance is lenient jurisdiction and exploit gaps. International copyright norms are breaking down.
So, I'm Devarajan. I'm continuing the next point. The real problem is indivisible human creativity. The law isn't asking that the right question. We keep asking that is an AI an author, but we should looking into it. Where is the human creativity hiding in this process? So, because the truth is in human involvement in AI creation rarely absent, but often it's invisible because and consider the three form of human creativity that exist law completely misses. First one, prompt engineering. A user doesn't just type generate a painting. A sophisticated creator design a detailed prompt that controls style, tone, and narrative arc, like a director guiding a cinematographer. Is that authorship? Yes, but the law doesn't recognize it as an authorship. So next one, iterative refinement. A human generates output, reject it, modify it, regenerate it, and select again and again. This mirrors that traditional drafting and sketching, but the law it treated as a mechanism who is facilitating all this process. And third one, curation and modification. After the AI generates thousands of variation in the one model, the human select one of it and modify against it. That creative judgment of the human that select among alternative based on the aesthetic vision is genuine authorship with the human, but yet law ignores it. The problem exists. Existing tests are too crude. They are swinging between two extremes. Either grant authorship where the human involvement in minimal, that's overproduction, or deny a protection where human played a substantial role in indirectly, that's our underproduction.
So the solution we produce here is the three-tier model. A three-tier human authorship framework that distinguishes between three levels of human involvement. Tier 1 A, autonomous work. These are works generated with negligible human input, generate prompts like write a poem or create an image. The AI makes all creative decisions autonomously. So hence, there is no copyright protection. They falls into public domain. While copyright has always required human creativity, skill, and judgment, and AI, autonomous AI, lacks this. Next, AI assisted works is a tier 2. These are works where human defines clear creative parameters, objectives, and constraints. The AI act as a sophisticated tool like Photoshop or Word to execute human vision. So here, the full copyright protection is given and the human is the sole author. Why? Because the creative control, conceptualization, direction, selection, modification remains with the human. The AI is means to express human creativity and not a co-creator. Next, the tier 3 is the AI enhanced collaborative works. These are genuinely complex collaborations. The human and AI engage in dynamic, iterative interactions. The AI contributes unpredictable elements and humans'
Participant,
ambition influence
kindly
each
come to
other.
the recommendation and conclusion. Kindly come to the recommendation and conclusion.
Sure, sir.
So we are stating that doctrinal anchor, the substantial creative contribution test, SCCT, that we are contributing that a copyright protection is granted only these elements are presented in the SCCT. So first one, conceptual origination. Did the human independently determine what to express and why? If AI autonomously decide both the idea and expression, the human authorship fails. Second one, creative constraint. Whether did the human design the detailed expressive prompt that control style, tone, and direction? It depends on the human. But generative prompts are insufficient, meaning constraints reflect the creative vision. Third one, iterative engagement. We checked did the human continuously dialogue with the AI, rejecting, refining, reshaping, like it's mirroring the traditional drafting or not. Fourth one, selection or curation. When AI produce a multiple output, did the human exercise aesthetic judgment in selection of based on the creative criteria? And fifth one, post-generation modification. Did the human edit, restructure, or transform the output with the quality, information, or creativity to be checked? So these elements are more important to authorize is human. So this works because predictable and technological neutral and as well as judicial manageable. So next one to accountability and moral rights. One of the crucial point is moral rights belong to the exclusively to human. Human have dignity, identity, and reputation. Machine does not have anything. When AI generated content is defensive or offensive, we can't blame the AI absolutely. Human who developed it and exercised its creatively control, they bear the responsibility. Proposed reform is mandatory disclosure of AI in creative work. This protects the human creator's reputation and ensures accountability remains anchored with the human, not the machines.
So to conclude, I would say copyright has always evolved from photography film to digital media. Each technological shift prompted fears. Yet copyright survived by adapting, not abandoning its core values, safeguarding human creativity and respecting the human soul. creativity and expression. AI should be treated as a part and essential threat to copyright. If we cling to the outdated analogies, uncertainty will discourage creators. Opportunistic claims will flourish. Genuinely creative work will go unprotected. But if we adopt clear standards, if we have honest engagement with how creativity actually happens in the AI era, copyright can adapt. Because at its core, copyright is not about machines, it's about human creativity, human expression, and human responsibility. Preserving that in machine-driven era doesn't require resisting innovation. It requires understanding it carefully and keeping the law's underlying values firmly in view. Thank you.
All right. Thank you. We can move ahead with the next.
Next, we have Ishpreet Singh from Himachal Pradesh National Law University.
Participant, you are not audible. You are not audible, participant. No, you are not. If there is network issue, we can move ahead with the next, and then we can call you.
Up next, we have Nandana Mohandas from Symbiosis School. Nanda, are you present?
No, participant is not there.
Okay, next we have Saroja Devi from Wells Institute of Science, Technology and Advanced Studies.
Can you just give me a few seconds to share the screen? Is it audible? Is my screen shared?
No, your screen is not visible, but you're perfectly audible.
1 second, 1 second. Sorry, I can't able to share my screen. Can I present like that?
Okay, you can give your presentation after the presentation. Kindly share your PPT.
Yeah, sure. I'll share my PPT. Yes. My topic is the blockchain and distributed ledger technology for IP management. The introduction is IP in the 21st century has become the main role of the innovative growth economically, with the intangible assets holding unprecedented value. However, new complexities and vulnerabilities that flight the current IP management and enforcement mechanism. Some of the existing landscape characterized by complex ownership issues. That is technological reforms like AI-powered monitoring tools, streamlines digital platforms, blockchain-based ownership verification will play a role by giving a solution to these issues. So now come to the blockchain and distributed ledger technologies. That is, both blockchain and distributed ledger technologies create a trustworthy and transparent record by allowing multiple parties to a transaction to verify what will be entered into the ledger in advance, without a single party having the ability to change any ledger entities. Later on, the both act as a payment of cryptocurrencies, digital representation of value, and represent the best known use of TLT. The regulatory and legal framework surrounding bitcoins that reform fragmented across countries. with some implement or explicit banning them and others allowing them. In order to next one is a limitation of the traditional IP management system. By viewing the limitation, the IP administration has always required a lot of effort and resources. Patents are one of the most important component of IP strategy because it needs to go on to the large databases. However, the procedure may be insufficient due to the need for them to manually utilize. Due to the heavy reliance on human groups in classification and analysis, the portfolio management is being subjective and it lost opportunities. And the restrictions made it more difficult to take action and needed to leave the organization vulnerable. The next one, when I come to the blockchain-based intellectual property registration and proof of authorship. The blockchain technology for the designs and trademarks made the registration procedures more efficient by eliminating some of the process in procedures. We say, for example, some of the trademark application to show it is not possible for the trademark to be inherently distinctive. So by assuming the necessary to be updated in the law to proceed for the actual use of the trademark in the blockchain, to be added or recorded as an evidence on the official register as actual use of the trademark as well as frequency of the usage. And it will be easily available in the blockchain and it can be easily utilized for the future, that is later on. It can save time and cost. It is permitted to everyone to view on a blockchain. In the concept of intellectual property, is available in the WIPO in the way of facilitating to gain better understanding on blockchain by its potential use. So the unregistered IP rights, that is the unregistered design rights and copyright, the blockchain technology helps in creating the potential assets and it can easily give evidence that's rights, management information and jurisdiction needs. Any member of the public can upload the rights management information by way of time-stamped entry. The blockchain-based registry would be useful. It is an authoritative and trusted third party that was involved along with the IP office. That is a collective management organization. Next one, I'll move on. Sorry, now I can see that my PPT is shared. 1 second. Next one is blockchain application in copyright management. So the benefits that the copyright registration, it provides the transparency process that creates the tamper-proof digital records of copyright ownership and transfers, gives the support that the data is secure and cannot be deleted. Next one, it creates the tamper-proof record of copyright ownership that helps to solve the disputes of copyright infringement more easily.
You can move to the recommendation.
Yeah. The main thing is the aspects of IP management in a smart contracts, that is the copyright protection and patent management and trademark registration. These three plays a major role in the aspects of IP management contracts. I'll conclude with once again. The blockchain and distributed ledger technologies is recorded, managed, and create a great significant change in a way. These developments, technologies move forward in critical weaknesses of IP traditional systems, cross-border coordination, proof of ownership, and the smart contracts gives the trustworthy solution to the challenges of IP management and protection. The challenges that mostly we face is a privacy issues, scalings, and the legal uncertainties that has to be clearly prospectus in order to realize the smart contracts to the full potential in IP management. In the digital world, where the growing innovation and technology cooperations between the legal experts and industrial stakeholders. However, the use of blockchain and IP managements need the hybrid approach towards attaching the technologies with the policy support and the cooperation deal internationally helps to sustainably trust efficiency and towards the areas in global IP management system. That's all. Thank you for giving me this opportunity.
Okay, thank you. There is no question for you.
Yeah, thank you. Yes.
We can
Next,
move
we
with the
have
next.
Ishpreet Singh.
Good afternoon, sir. Sir, am I audible?
Yes, you're audible.
Okay. Sir, I hope you can see my presentation.
Yes, we can.
Okay, sir.
Yeah, you can start with your presentation.
Okay, sir. Sir, so first of all, I would like to express that the title of my presentation is Synthetic Performances, Real Harm, Copyright Failures, and AI Exploitation of Vulnerable Actors in India's AI Era. So, sir, in the very first image, you can see that in the lead, you can see Janvi Kapoor, and then in the behind, there is another model. So, to clarify, this presentation is not about the Shah Rukh Khans and Amitabh Bachchans of India, but it is about the struggling actors and junior artists who work day and night in the entertainment industry and are every day vulnerable to their rights and duties. So, I'll continue. So, sir, the main problem of this paper is that as we know that generative AI enables synthetic voice, face, and performance replication. It can clone your voice, body, face, everything. And the Indian Copyright Act protects only actual performances. So now what I mean by actual performances is that in the statute it has been clearly referred as to live and recorded performances which have already been performed and has yet not to be in the original sense. And then sir, these AI generated replicas fall outside these performances rights. Why? So I will continue. These are some crucial provisions from our Indian Copyright Act statute. And why are they insufficient? It is because, sir, they protect only live performances, broadcasted and communicated to public. What they not protect is, sir, that the use of voice, a performance can be created just by cloning the voice. So, sir, the main contention is that there need not to be any performance already. The machine can already take your voice and create an absolutely new performance that has never been performed before. So, what is the solution in that case, sir? Moving on to the next slide, sir. So the critical strategy exclusions. So if we clearly say read the provision of section 2Q where the definition of performer has been given. So first of all, the statute does not define actually what a performer is, but it just gives some categories such as actors, dancers, jugglers. But in the proviso itself, it says that the incidental uncredited performers would be excluded from all the rights that need to be given in the copyright statute, which sir, creates a class of, as I have titled, invisible performers. Giving no credit does not mean that the labor of the performer is not going in, he is still vulnerable. And the interplay of generative AI with this becomes even more dangerous. By moving on next, sir, generative AI as a legal disruptor. Sir, voice cloning from seconds of audio, facial deepfakes, and synthetic acting. You don't need to perform. Just you need to come on set, give your voice, and your voice is to the studio, and it can be replicated in any new performance. So, sir, the key question is AI output an infringement when no actual original performance exists in the real place? Moving to the next slide, sir. Why performers' rights fail in the current Indian Copyright Act? Rights attached to performance, not persona. No infringement without fixation or act. AI replicas are legally new performances. Therefore, copyright logic collapses. Courts forced to rely on personality and privacy doctrines. As we have seen the recent cases, I have also put in the paper, whether it would be the case of Anil Kapoor or Aishwarya Rai Bachchan. So the criteria for giving a personality right is that you need to have a celebrity status. Only then you could be given that right. So that keeps the performers who are yet not a celebrity in a very vulnerable position. That is the main contention. Moving on to the next slide, sir. Absence of personality publicity rights in realm of vulnerable performers. No codified personality rights in India. Judge-made protection via passing of privacy trademark logic. It requires celebrity status. Vulnerable actors fail threshold acts. Moving on next, sir. Comparative developments. Beijing Treaty is still not ratified by India, and it should be because it does not leave out uncredited performers and it attributes to all the performers, whether it is a scene or a whole film. Second, sir, the EU AI Act has already been dealing with deepfake disclosure and regulation. As I have compared in the paper, whether it is UK or Denmark, who have already passed the copyright like right over voice and likeness, which is in close resemblance to personality rights, but there need not to be any celebrity like status. And the next, sir, identity increasingly treated as protectable interest. To conclude it, sir, the last recommendations that I would give is that in the current Indian Copyright Act 1957, the definition of performance and performer must be expanded to incorporate the intricacies and nitty-gritties of AI, generative AI, and the challenges that it brings with it. The statutory personality right for all individuals and not celebrity status being a whole criteria. Third, sir, remove exclusion of incidental performers. There should not be any credited for uncredited performers because every labor of every performer counts, in my opinion. And fourth, sir, AI specific consent and royalty clauses. Whether you are coming on the set for 1 day or 7 days, there must be a proper clause for it and you must be remunerated accordingly. And if your voice or face has been used without your consent, you should be compensated for that as well. And sir, at last, Beijing Treaty, it is important to be ratified because it leaves no class of performers unprotected. Therefore, sir, the main goal and the main intention of this paper is to protect the dignity, labor, and consent of vulnerable performers in the current AI era. Thank you, sir. I'm done with my presentation.
Okay, all right. There's no question for you.
Thank you, sir. It was a pleasure presenting to you.
Okay.
Next, we have Nandana Mohandas. Nanda, are you present?
Hello, can you hear me?
Yes, we can.
Okay, good. I'll just present my screen.
Participant, your presentation is not visible.
Sir, I'm just presenting and it says processing.
Okay. You can start with your presentation. Once it is visible, it will be...
Can you see it now, sir?
Yeah. Yes, you can
Okay.
start.
Yes, sir. I'll just start in 1 minute. Good afternoon, everyone. I'm Nandana Mohandas. I'm a student at Symbiosis Law School, Pune. And during the writing of this abstract, I basically started with my research into the handloom sector. So the reason I've done this is because I've read a lot of news recently about how even though GIs have been getting more recognition, especially post the Kolhapuri scandal, there's still a lot of lacunae in terms of how this is being viewed by the public and how these benefits are really trickling down to the vulnerable population. In fact, when I started doing my research, what I understood was that in the handloom sector, the amount of women representation, although they make a significant part of the workforce, is much lower. Um, if you look at the press release reports of the Ministry of Textiles, you'll notice that women make up almost 70% of the workforce as far as 2021 was concerned. And this number hasn't changed. Number hasn't changed a lot, which means it's high time that they also have sufficient representation in this area. The first thing that I'd like to address then during the presentation is the fact that
there are different theoretical frameworks to understand why women have not been a part of this conversation or why they've not been a part of benefit sharing mechanisms. So, as we all know, geographical indications came through the 1999 Act and the TRIPS Agreement, Articles 22 and 23. Later on, India has also adopted it. We have multiple, we have almost 65 just handloom geographical indications itself. There are three theories that I'd like to briefly touch upon. The first one is by Joan Acker. Through this theory, what this author basically says is that the entire idea of organizational hierarchies are itself made in such a way that women are not able to access it. This usually is the fact that the women we're looking at here in the handloom sector are probably people without a lot of formal education or access to anything that might help them alleviate their current struggles, which means the entire idea of registration and the legal ideas behind it are also only something that the men can access. The second and third theories further build on this. In fact, Shulamit Firestone is somebody who's written in the 1960s. And unfortunately, what still seems to be true is that all of these theories are very much applicable to the Indian handloom sector. Further, what I'd like to talk about are two case studies. Number one is the Kanchipuram silk sarees case study from Tamil Nadu. So this is from the Kanchipuram district. It's also called Kanjivaram, and the spellings may differ. A lot of study has been done into this, considering that it's extremely culturally important to Tamil Nadu as well. And what I have understood from my literature review of a lot of these studies is that number one, it is a sector that has a lot of skilled labor but unorganized sector, which is to say that these people have been apprentices and have been getting experience and training under experienced artisans for years together. And as a result of this, there's a lot of important skilled labor within this area. Now, what this also means is that comes with a few other struggles. Number one is the fact that mechanization of textiles gives them a lot of competition in terms of getting any real value. And secondly, there are a lot of constraints to GIs. This is also seen in the case of Chanderi silk sarees, which is from Madhya Pradesh. However, a successful thing that was seen here is that when women were arranged into self-help groups and they were able to pool in their resources, they were able to much more be a part of this process. And this is important for a multitude of reasons. But most importantly, let's understand how this is relevant and what my policy recommendations are. Number one, as far as the GI Act itself goes, the definition of producer needs to be a lot more inclusive. It needs to include people who are included in all stages of production. This usually means that currently the only people who have access to this protection under the handloom sector are the people who are the final weavers. However, there's a lot of people involved in the tie-dyeing process, in the process of maybe ancillary work, and most of this is usually done by women who are not a part of the formal, maybe the organization itself. And it becomes important that they become a part of this conversation. Secondly, gender impact disclosures. It's important that through a reform policy, what we could possibly look at is that women and their ability to participate is increased by ensuring that there's some sort of mandatory reservation, and largely ensure that all process of the registration are also made for women, in the sense that it's made more language accessible, and there's also registration drives that make it possible for them to access the same. So that is my conclusion. If you have any questions, I'd be happy to answer them.
Okay, there's no question for you. Thank you. We can move ahead with the next.
Up next, we have Parthiv Nair.
Yes, participant, kindly present your screen.
Can you see the screen, sir?
Yes, it's visible. You can start with your presentation.
Good afternoon, everyone. We are Arya Krishna S. and Parthiv Nair of Government Law College, Ernakulam, presenting our paper titled Reaffirming Intellectual Property Rights in the Metaverse, Closing of Legal and Jurisdictional Gap. So, through this paper, we aim to prove the inadequacy of the traditional intellectual property laws, which were designed for territorial and physical context in the metaverse. And we also provide some plausible solutions to the same. Moving on, before understanding about the violations in IPR, let's first understand about the metaverse. So, metaverse is a convergence of virtual reality, augmented reality, AI, and blockchain. It enables real time interaction through avatars and also supports ownership and trade of digital assets such as NFTs and virtual real estates. So, moving on, intellectual property in metaverse. So in metaverse, the use of avatars by the users to the metaverse platform itself are intellectual properties. The intellectual property is the foundation element for generating economic activity and growth in the metaverse. Many companies are introducing their trademarks, digital products, and even their designs to the virtual markets inside the metaverse. Virtual goods and trademarks which exist in the metaverse is worth $1 billion. And many luxury brands such as the Gucci, Louis Vuitton, and Hugo Boss are selling their e-products in the metaverse. Reliance forms the first Indian firm that posted earnings call on the metaverse. So, moving on to the violation of intellectual property rights, the codes form the basis or the building blocks of the metaverse, and the replication of codes of metaverse can result in digital replication of various properties, such as the unauthorized use, sale, and even replication of well-known brands in virtual environments. Also, easy duplication of digital artworks and designs, and also the misuse of trademarks in virtual goods and NFTs are common. A major case in this is the AM General LLC versus Activision, in which the Activision used the military vehicles in its video game Call of Duty without the permission of the AM General LLC. Moving on, one of the major first landmark judgment involving the intellectual property rights violation in the meta world is the Hermes International versus Mason Rothschild's case, in which the court restricted Rothschild to use and duplicate meta working, which caused consumer confusion and trademark dilution. The judgment was passed in favor of Hermes, restraining further use and awarding damages to Hermes. This case is considered as the one of the major landmark cases. The rest of the presentation will be dealt by my co-author, Fateh.
Okay, now let us look at the legal and jurisdictional gap in the regulation and protection of IPR in metaverse. So, the traditional IPR laws are territorial jurisdiction, which are confined within the net border of the territory or a country. But the metaverse is borderless and its scope is global. So the traditional IP laws are inadequate to deal with borderless metaverse. The second one is due to global scale of metaverse, IP laws of different countries may contradict. A prime example is expiration of copyright in India is after 60 years of the death of the author, while in European Union countries it is 70 years after the death of authors. The third one is due to the global nature of the metaverse, it is difficult to fix the jurisdiction of the violation because the users are from the different corners of the world. Also, it is difficult to fix the identity because the users may mask their IP address by using VPN, and the infringers of the IPR may be build themselves using many fake IP addresses. Also, the another problem in a legal gap is because there is no clarity on whether to give separate legal identity to others and users. There is an ongoing argument between experts in this matter. So, what is the way forward? Some suggestions by us are: there is an absolute necessity of an international intellectual property treaty between countries for creating uniform IPR laws among all countries which are part of it. Also, a body should be created under the treaty, which would provide individuals and companies a chance to register their intellectual properties, and these intellectual properties will be protected worldwide and every corner of the world. Also, an AI-powered masking detection system should be incorporated in every metaverse platform, which would detect those users who are masking their IP addresses and their location using the VPN technology. This would help in identifying the real infringers of the intellectual property. Also, the jurisdiction of the to judge the infringement of intellectual property right should be on the country in which intellectual property is issued. Also, avatar should be given a separate legal identity, just like the companies. The avatar should be made legally responsible for the infringement of an intellectual property right. Also, the user should be vicariously liable for the infringement made by the avatar in the metaverse. So, the Helm curve confirms that IP rights apply in virtual environments. The traditional IP laws must be adapted for NFT and metaverse platforms. There is a need for international cooperation and harmonized regulation, and there is a need of a clear international legal framework to protect creators and brand owners. Thank you.
Okay, there's no question for the team, so we can move ahead with the next.
Up next, we have Nishi Shabana and Rajdeep Datta.
Good afternoon, everyone. Um,
Participant, your presentation is not visible.
yeah, I'm trying to do that 1 minute. Is it visible, sir? No? Is my presentation visible?
Yes, you can start with your presentation.
Okay. So the topic of today's why is it not working? Just a second, sir. Give me 1 moment. It's not. So the topic of today's presentation is algorithm as accomplish. And I'm Nishi Shabana. I'm a practicing IP lawyer as a partner with a firm named Leum Legal. So the topic is an algorithm as accomplish, and in the as an infringement in today's e-commerce marketplaces. So why this is important to discuss today is to understand the shift from the shelf, from the physical shelf to of the product to the digital shelf, which is to fundamental shift of the product from the physical shelf to the pixelated screen. And in for example, in store we get a confusion come from a similar looking boxes placed nearby, but in online that shelf is now an algorithmically sorted feed, and the point of sale is the website or an in-app product which is very lookalike and similar to what is available on the shelf. So the purpose is not of buying a infringing or a counterfeiting product, but a dupe culture in which the point of sale is a website or an app, and infringer is looking for a lookalike and a dupe of a luxury brand, not the luxury brand in itself. The look and feel of the product is what pushing to the consumers at this point of time. So how this mechanic work basically? The mechanic works with the look alike, the trade dress. I mean, it may not be the consumer may not be looking for a Gucci counterfeit bag with a Gucci logo of it, but maybe the look and feel of it, the color of it, the main stitches, and the go and the feel of the product. So the look and feel, it is not the logo and the logo of the which they are looking for, but maybe the product in itself, which is very look-alike on an original product. And this exploits a gap in our Trademark Act 1999, which protects the logo well, but overall product design and a trade dress is not protected. And the consumer see the familiarity and a fresh desire to click, and often realizing it is not original. For example, the red sole of Christian Louboutin, not actual red sole, but a shoe with a red sole. So algorithm, how an algorithm as an accomplish comes here. Algorithm, where the problem is escalated, the e-commerce platform and the social media are not a passive billboards now. They work on an algorithm which prioritizes the engagement and transaction. And when you search for a brand, an algorithm uses dynamic keywords. Say, for example, they will come up with a Shopper Stop, or they will come up with a Zara, or more often, they'll come up with a sponsored post, or frequently bought together, because through their algorithm, they have learned that the user who like brand X also clicks on the cheap lookalike. So algorithms start actively pushing this infringing product into the feeds of the brands of the potential consumer. The platform transitions from the neutral host to a very active participant in the creating that deception. Now, where are the
Participant move to the recommendation and suggestion.
Yes. So our recommendation is, we are not. If you see we can have a lesson for the European Union Digital Service Act. We don't have to reinvent the wheel. The EU Digital Service Act has provides proactive blueprint for that. Traceability of the traders like KYBC, Know Your Business Customer Platform. Verify your identity before they can sell. Stripping away anonymity that fuels the dupe economy. The secondly are trusted flaggers. They are designated IP expert where they can flag the infringement, and platform must prioritize those, and the algorithmic risk assessment for the platforms. So what we recommend here is not a metaphor. Basically, it is a tripart regulatory reform for India. First, mandatory KYBC verification to end the seller anonymity. Second, the statutory recognition for the trusted flaggers for the faster enforcement. And third, establishing duty of care, where the platform loses their safe harbor immunity if their algorithm forces a fake lookalikes into the in their feed or in their platforms. This is what we recommend. Thank you.
All right. Thank you for your presentation. We can move ahead with the next participant.
Next, we have Manasvi Joshi.
Am I audible and visible?
Yes, you are audible and visible. You can share your presentation.
Just a second. Is my presentation visible?
Yes, it is visible. Kindly start.
Okay. Good afternoon, everyone. My name is Manasvi Joshi, and my research explores the complex intersection between cultural heritage and intellectual property rights. In an era of rapid globalization, we are witnessing a grave clash between modern IP models, which are designed to protect individual inventors, and traditional knowledge systems that are communal and intergenerational. Today, I will take you through the challenges of cultural appropriation, the limitations of current legal frameworks like TRIPS, and how countries like India, New Zealand, and China are pioneering solutions to protect their heritage without stifling innovation. The fundamental problem that lies in the design of our legal system is that intellectual property law, which originated in 17th century Europe, assumes a single creator deserves a monopoly for limited time. However, cultural heritage, like a folk song or a weaving technique, doesn't have one author. It belongs to a community and evolves over centuries. Because these traditions don't fit with the strict definition of novelty or authorship, the law often treats them as a part of the public domain. This legal loophole is what allows corporations to commodify sacred traditions without permission or compensation. So, how do we fix this? My research categorizes protection into two types, defensive and offensive. Defensive protection is about shielding knowledge. The best example is India's Traditional Knowledge Digital Library, or TKDL. Instead of patenting every single remedy, India documented over 4 lakh formulations to prove that they already exist, making them prior art. So foreign companies can't patent them. On the other hand, offensive protection uses tools like geographical indications to help communities actively monetize their heritage, ensuring that if you buy champagne or pashmina, it actually benefits the region that created it.
The fashion industry is a major battleground. We frequently see inspiration cross the line into exploitation. Taking the case of Isabel Marant, who used designs identical to the Mexican community's Hupil embroidery from Mexico. She sold these as boho chic luxury items, while the community for whom these patterns have significant cultural meanings saw no benefit. Similarly, Dior faced backlash for using Rajasthani block prints without proper attribution. These aren't just prints, they are markers of identity when they are mass produced as generic commodities. It erases the history of the people who sustained them. Moving on with how the Indian model is, India is a global leader in this space. As mentioned before, the TKDL is a paradigm shift. It translates ancient Sanskrit, Urdu, and Tamil text into languages patent examiners can understand. This simple act of digitization has successfully blocked hundreds of enormous patent claims on things like turmeric and neem. Furthermore, India has aggressively used geographical indications by securing GI tags for products like Polchami Ikat. We ensure that market value for these goods remain with the artisans. It's a model that shows law can be adapted to serve tradition rather than just economies. Going beyond the Indian landscape, we see innovative approaches like New Zealand, which offers a powerful example with the Maori haka. It wasn't protected by copyright, but by a special sui generis law that recognizes that Nyakti Toa tribe as its guardians. This requires commercial users to attribute the tribe and prevent the haka from being used in offensive contexts. Similarly, China's 2011 law, which focuses on transmission of heritage, supporting the masters who teach skills like ceramic making. These cases prove that we don't have to rely solely on Western IP models. We can write new laws that fit our cultural context. Uh, Despite the successes, there are significant gaps that remain. The biggest challenge is the concept of ownership. Who signs the contract for a community song? If tradition evolves, how do you copyright the original version? Furthermore, the digital age possesses new threats like AI and digital printing, allowing for rapid replication of involvement. And practically speaking, even when we have GIs, we often see that profits are captured by middlemen rather than the artisans themselves. Legal recognition is one step, but economic enforcement is a harder battle that we are yet to achieve. To conclude, my research suggests that cultural heritage protection is not just about the economics, it's about justice and identity. We cannot rely on a one size fits all Western IP model. Instead, we need a hybrid approach using GIs for economic leverage and sui generis laws for moral rights. We need to empower communities with a veto right against offensive use of their culture. Ultimately, intellectual property must evolve. It should not just be a barrier that strips communities of their assets, but rather a bridge that allows them to share their culture with the world and on their own terms. Thank you.
Okay, there is no question for you. We can move ahead with the next. Thank you.
Thank you for allowing me to present today.
Next, we have Ananya Purohit from Christ University.
Yes, good afternoon, panel. I'll just share my screen shortly.
Participant, you are not visible.
Just a minute, sir. Yes. I hope I'm visible now.
You had joined from two places.
Yes, sir. So just as to ensure that there is no auditory lapse in between.
Okay, yeah. Share a screen. Yeah. You can start with your presentation.
With this, I hope my screen is visible.
Yes, you can start your presentation.
Yes, sir. With this, good morning, panel. Before we start with the presentation, I would take a few moments to delve deeper into the complexities of the very title itself. So, the title kind of sheds a lot of light on the discussions that we are having around traditional knowledge. Most of our discussion on traditional knowledge are focused on protection, right? So it is how to prevent theft and misappropriation. We talk a lot about how do we provide access and benefit sharing frameworks, how do we recognize the rights of indigenous communities, right? And how do we prevent theft and misappropriation. But this particular paper wants to shed light more than protection to recognition. And this is a very deliberate effort to see as to operationalizing epistemic justice, not just as a moral or philosophical concern, but as an institutional concern, wherein we see that there are certain evidentiary pathways wherein we consider traditional knowledge as a valid evidence into building innovation. Now, where does the problem lies? Is the problem in recognition? No, the problem is not in recognition. There are no missing laws. We do have international conventions. We do have Indian statutes as well. We do have CBT. We do have our own IPR rights. There's no bad faith patenting, lack of protection. The Indian statutes are very well willing to provide ownership right to innovators. So the problem is as to how patent system define knowledge and how innovation is evidentially recognized and treated as evidentially credible. And therefore, there is a conscious effort in order to reframe the particular matter from defensive protection to a kind of protection where we put traditional knowledge at the forefront of it. Our current patent system, they privilege written disclosure, laboratory-based validation, individual inventorship. Since they have been bought well from Western-dominated system, which are very much individual-centric, they fail to recognize community knowledge as something that can be patented as well. Because traditional knowledge does not fit well into the criteria of what patent system provide now. That is, since they are oral and practice-based, contextual and cumulative, and communally produced. And therefore, while we see that there are a lot of shortages within the current system, another one is defensive protection. What it fixes and what it doesn't. So defensive protection was a conscious effort taken through TKDL, that is Traditional Knowledge Digital Library, in order to prevent misappropriation and block false novelty claim. For instance, there was a turmeric case wherein we used defensive protection to say to US, no, you're not doing this right. We already have turmeric healing power as traditional knowledge embedded in TKDL, and therefore you cannot claim patent over it. But then again, there have been a lot of innovation that has been done keeping this particular information as a baseline, right? So there is a good chance that defensive protection do not reframe innovation standard and therefore do not recognize traditional knowledge as innovation capable as well. Where is the core contradiction? So the core contradiction is that if traditional knowledge is documented, it risks misappropriation. If it is undocumented, it is treated as epistemic closed. So if I do give right to communities, I will not be able to patent it. If I do not give right to communities, there is a good chance that, there a source of innovation will get lapsed since I'll not be able to build upon it. And due credit will not be given as well. Now, this problem again intensifies contemporarily because of the very fact that we are using a lot of these systems because of climate emergencies and sustainable agriculture that we as Viksit Bharat are trying to prevail over. And we see that we have introduced digital TK documentation system as well, which are AI assisted. And when comes in AI, there comes in bias because again, AI has been trained over written, well documented information system, right? However, AI logic tells us that if there is a presence of a traditional knowledge, there is an existence of the same. If there is absence of traditional knowledge in TKDL, there is non-existence of the same, and therefore it won't be recognized. We get into the theoretical lens of it, we see that this is the very point we asked as to what is epistemic justice. Whose knowledge will count? How will
Kindly come
credibility
to
be
the
assigned?
suggestion and recommendation. Kindly come to the suggestion and recommendation.
Yes, sir.
Participant, your voice is not audible. Your voice is not audible. No, it's not audible. Host, can you listen, huh?
No, sir, I can't.
Okay. It's not audible. It's not
Your
audible.
mic is turned off actually. Please turn on your mic.
She was presenting from one camera and she is audible from one other account. Yes, you are now audible. Yes, speak.
Am I audible now?
Yes, yes. Don't waste time. You can come up with
Okay.
your suggestions.
Yes. So the proposal is the proposal tells that we have to move from diagnosis to solution. That is, we have to shift our evaluation from whether is this particular traditional knowledge written to actually think of a possibility that there may be a lot of innovation that has been done keeping traditional knowledge as a baseline, right? So therefore, from is it written to does it systematically solve problems? And therefore, in order to do that, we need to include certain evidentiary standards that are equipped to handle traditional knowledge of South Asian countries. At the same time, we see that since our examiners, that is patent examiners, are trained upon the system that is Western dominated, it is very much essential that they be given the required tools to go beyond what is there already in the searchable databases and see as to whether there is any innovation over the line of top of traditional knowledge. And therefore, traditional knowledge should not just be seen as defensive protection, but at the same time should be seen as a way that can provide innovation in the long term. Then AI compatible traditional knowledge systems, there should not be a black and white area. There should be a gray area deliberately so that there can be more manual searches in order to see that whether the traditional knowledge can be patented or not be patented, since traditional knowledge also carries a very good possibility of being evolved over the time. So the conclusion is that the paper is trying to argue that traditional knowledge is not a static heritage. It is a living innovation system, and therefore it should not be restricted from not being patented at all. We should question the possibility of all the innovations that have been built upon traditional knowledge as a baseline, and therefore we should see that if there is a real chance of being able to recognize all those innovations and not let them swipe across just because they do not uh, qualify into some of the criterias of patent system, because community knowledge is not something that was kept in mind while designing the patent system itself.
All right.
With this, I'm done with the presentation, sir.
All right. Thank you for your presentation. We can move with the next.
Thank you, sir.
Next we have Aishwarya Singh from Hidayatullah National Law University.
Good afternoon, panel. Am I visible and audible?
Yes, you are visible, audible, and your presentation is also visible. You can start.
Okay, sir. So the paper tends to address the questions of inadequacies of the legal frameworks, then implications of the TRIPS framework, then conflicts with the customary legal systems, analyze the cultural misappropriation in the case of Kolhapuri chapels, and highlights the recent developments and proposes the sustainable protection. So, the paper discusses the failure of a conventional IP frameworks. That is, the current legal framework tends to fail to protect the traditional fabrics and cultural expressions against the speculative appropriation by the luxury brands. So, the traditional cultural expressions are vulnerable because they are oral, non physical, and collective nature often places them in the public domain under the modern IP law. So, the failure lies here that The TRIPS tends to cover these under the Article 23 and 22, which tends to be the inherent biasness in the two-tiered structure of TRIPS. For example, when it comes to France, France has protected the name champagne. So, a champagne which tends to be generated or made up in California can't be titled as Californian champagne. The shortcomings of the geographical indications. While GIs protect the place of origin, they fail to safeguard the aesthetic designs, cultural meanings, or the collective integrity of heritage. Moreover, the focus of the TRIPS is on trade and utility. TRIPS prioritizes the market efficiency and preventing unfair protection over the human rights or cultural preservation. There has to be distributive justice. That is, the current system lacks a framework for distributive justice, leading to uncompensated use of communal assets by the global commercial actors. The domestic regimes and India's framework. So the domestic regimes for the patchwork, that is fragmented domestic implications of TRIPS, is sui generis, trademark or hybrid, creates the global legal uncertainty. India's legal framework for GI is sui generis and it tends to protect items like pashmina and silk but lacks the sufficient resources to empower the small scale producers. Moreover, taking the example from the Mexico's hybrid approach and legal protection, Mexico came up with a hybrid approach. Mexico combines the industrial property legal laws with groundbreaking new legislation passed in 2022 to protect its indigenous heritage. They came up with collective ownership. That is, Mexico formally recognizes indigenous communities as subjects of public law with inalienable collective rights to their cultural legacy. The customary law at the essence of the originality, that is, the invisible fabric. Customary laws act as a third legal system that is binding within the communities, but they are often ignored by the international agreements. The IP requirement for originality conflicts with the traditional designs that are collectively developed over generations. So the larger companies tend to exploit them easily. Failing to recognize the spiritual or communal claims allows the luxury brands to commodify these sacred symbols for their own profits. Moving on, there are some case studies which addresses the misappropriation. So the Hupil of Mexico, these brands were accused, the Hupil of Mexico, that is the people of the origin. So Zara, Anthropology and Petovel, these three were the communities whose designs were copied. So Zara, pertaining to a clothing perceived to resemble the needlework found on Mexti Hupilis from the San Juan, Colorado, located in Oaxaca, the ministry underscored that the traditional hupil transcended mere clothing. It embroideries the identity of the women who created. The designs draw inspiration from the community's historical motifs and lifestyle and are crafted using a backstrap loom. Zara copied it, and this act was guarded by the Mexico legislation. Moreover, Anthropology, the brand faced allegations of appropriating a design from the Mixi community of Santa Maria. Then the residents of Petovel, they asserted that the corporation appropriated a design from the Zapotec community and in San Antio Castillo, Velcasco. It was asserted that these designs were created by an intricate manual technique and embodied the historical memory of the Zapotec civilization. Now here lies the territorial trap. That is, the GI, if we draw the comparison, India's GI tag,
Participant,
GI tag,
kindly
yes
come
sir.
to the recommendation and suggestion.
Okay, sir. So there has to be advancing in the pluralistic framework. That is, the paper advocates for a legal pluralism where international, state and customary laws coexist to empower the communities. Moreover, the community protocols and benefit sharing. The local protocols and the Nagoya protocols provides for the blueprint, and we need to elaborate on that. So there needs to be equitable negotiation between the communities and commercial actors. There has to be revised international standards. That is, ongoing WIPO negotiations aim to create a new culturally attuned legal institutions that transcends the limitations. We can also see in the case of Parada and Kolhapuri Chappal turning case, where the WIPO 2024 amendments were brought in. Thank you, sir.
Okay, thank you. We can move ahead with the next participant.
Next, we have Naina Kushwaha from GD Goenka University.
Yes, participant, you can share your presentation.
Is it visible?
It's not visible. Yes, it's visible. You can start with your presentation.
1 second. Okay, good afternoon, everyone. I'm Naina Kushwaha, a PhD scholar, and my research examines when traditional knowledge is digitized and increasingly used by AI and digital platform. Does this process actually preserve culture, or does it open new pathways for misuse and exploitation? To begin with, it is important to understand what traditional knowledge is. It refers to community based cultural expression, such as art forms, symbol, motive, designs, and practices that are passed down across generations. These are not created by one individual but belong collectively to a community and form an important part of its cultural identity. Today, digital technologies and AI have transformed how this knowledge is documented and accessed. Moving from definition to context, we can see that museum archives and digital platforms increasingly prioritize online collections over physical engagement. As a result, indigenous and tribal art forms such as Gond and Varli paintings, Madhubani motifs, and tribal patterns from the northeast India are now widely available on the internet. However, this process often takes place without meaningful involvement or consent of the source communities. This brings us to the core legal problem, which lies in the mismatch between intellectual property law and traditional knowledge. Intellectual property law is designed to protect individual authorship, original work, and limited periods of ownership, whereas traditional cultural expressions, they are created collectively, passed down over generations, and governed by customary practice. And hence it can be said that once it is made available online, it is often treated as a public domain and it remains legally unprotected. This legal mismatch becomes even more serious in digital environment, and which leads to what I described as the digital displacement gap. Digitization takes the traditional cultural expression out of the community system. However, the law does not provide an equivalent form of protection, and as a result, these expressions become widely visible online, but they remain under weak legal and cultural control. This displacement becomes particularly visible when we examine how Indian intellectual property law deals with digitized indigenous art. And as we can see that uh, there is fragmented legal protection and not a complete protection for the digitized digitize traditional knowledge. Copyright law requires a clear identifiable author, which means it does not protect cultural expressions. Design law creates another serious problem. Traditional motifs are very old, so the communities themselves cannot register them as new design. When it comes to the GI Act, it is applicable to goods only which are linked to a specific territory, and the traditional knowledge digital library is defensive and focus on medicinal knowledge like Ayurveda. So we can say that digitization is not neutral, and when culture is shared online without consent, it is preservation without participation, and it turns into exploitation. So my suggestion is, first, it there should be sui generis protection, which means a special law made specifically for traditional cultural expression. Second, digitization should be consent based. Communities should be involved in deciding what is digitized, how it is shared, and for what purpose. Third, there should be ethical rules for access and reuse. They should not be copied, changed, or sold without permission or proper credit. And fourth, even after digitization, communities must retain authority. For the scope of research, first, there is a need to study AI training on digitized indigenous heritage, especially how community consent and rights can be protected. Second, further research, future research should focus on platform responsibility, examine whether digital platforms should be legally made accountable for cultural misuse. Third, more work is needed to translate the idea of sui generis theory to Indian legislation. And finally, because digitized cultural heritage spreads globally, future research must focus on international cooperation, with WIPO acknowledging that existing IP laws are inadequate and that digitization increases the cross border misuse, and on how India can work with WIPO and UNESCO to ensure community consent. To conclude this paper, I would like to conclude with one statement that digitization gives the world access to traditional knowledge, but when community loses control, it also takes away their identity, voice, and livelihood. Thank you.
Okay, thank you. We can move ahead with the next participant.
Up next, we have Srishti Rohila from NGP Rohilkhand University.
So, am I audible to you?
You are audible, but you are not visible. Yes, you are visible. You can share your presentation.
Okay, thank you, sir.
Yes, start with your presentation. It's visible.
Okay, sir. Good afternoon, all. I am Shrishti Rohila, a research scholar, and my co-author will not be able to present with me, so I'll be presenting this today's presentation. So the topic of my presentation is authorship in the age of algorithms, reassessing copyright ownership in the AI-generated works. Imagine a situation where a novel is written by a chat GPT or an image created by Midjourney. Though all these things look creative, effective, and novel, but all these situations put forward a very important question or a challenging question: then who is the author in all these situations? As we delve into the age of algorithms, there is a rapid proliferation of AI generated works across creative domains such as music, uh, art and literature, and even software code. This search presents very complicated question in today's time, that then who is the author of all these AI generated works? To understand the current challenges in the copyright law, first I would like to evaluate the evolution of the copyright law. From the Statute of NA to the Berne Convention, there has been a copyright evolution. But the core principle of the copyright law lies in the
Kindly come to your challenges and move to the recommendation and suggestion.
okay, sir. The challenges which has put the AI generated content in the copyright law is that who owns the copyright in all these situations? Who will be the author? Whether it will be the AI developer, the AI itself, or it will be left to the public domain. As the next challenges of the copyright infringement, as we all know that in AI, the AI is trained on a massive of data. So the question arises that whenever the data is put, that is also a copyrighted, and whenever the output is produced, that is also copyrighted. Like we have seen in the open AI case, there is a question of infringement, and all these have put forward the questions of fair use exceptions of fair dealing. Next challenges is that there is no compulsory licensing model where the creators are not fully repaid for their work, because there is no determination of who has really created the work. The next challenge is there is the AI generated work cannot be attributed the moral rights like humans can be given, like right of integration. Then in case of AI generated work, then who will be given all these moral rights? Next copyright challenge is there will be a complicated authorship of the stakeholders. When there will be no determination that who has actually created the work, then all will be claiming that we have created or we have created, and no, there will be no single individual to claim the authorship. Next challenge is that there is as there is no legal personality of the AI, then there arises a number of legal questions. For the next challenge which is put forward by the AI generated content is there are economic concerns. The when there will be no identification of the proper creator work, then who will be given the monetary claim, or who will be paid the royalty? Next is accountability question arises. Then when there is no proper identification, then who will be held accountable for the transparency issues or for the privacy
Participants
issues?
kindly move to the suggestion and conclusion.
To conclude with the suggestion, I will be recommending that there should be given a proper legal definition of the artificial intelligence across the globe, and the term author should be properly defined, which is not yet defined in the Berne conventions. There is only a human assumption that the author is a human being. Next, there should be a proper distinction between the AI generated content and AI assisted content. Like there are some examples which are autonomously created by the AI. Then the question the same arises that who will be the author in such AI autonomous contents. So there should be a proper distinction between the AI assisted and the AI autonomous generated. Fourth, the transparency and accountability should be the key point in framing the legal definitions. Fourth, there should be make a doctrine of work made for hire. Second, there should be proper tests and standards laid down for the classification of the human input. Fourth, there should be established a sui generis rights claim system, that is a separate definition should be given for the proper AI generated works. And last but not the least, there should be international harmonization, like the WIPO convention should work on it, TRIPS and Berne conventions. And at the last, I would like to conclude that AI may generate content, but authorship should remain with the human privileged.
All right. Thank you for your presentation.
Thank you, sir.
Next, we have Ashmita and Nafesa.
Good morning, sir. I'll be presenting my PPT.
Yes, you are visible and audible, but try to speak bit louder. Your PPT
Yeah,
is not visible. Your PPT is not visible.
yes, yeah.
So both of your camera must be on. Yes, it is. It is. Screen is visible, but there is no presentation.
No presentation.
Yes, PPTs is not showing. It's showing the Google Meet. Participant, if it is taking time, we can move to the next, and you can be called after some time.
Okay, sir. Sorry for the technical error. I'll correct it in
So
2 minutes.
next will be us, sir. Wait, sir. 2 minutes. Next.
Next, we have Ashima from Gujarat National Law University.
Good afternoon, sir. My name is Ashima Puri and I'm a research scholar at Gujarat National Law University. Just give me a couple of seconds to put in my presentation in view.
Yes. Yeah, notice to all the participant, kindly keep your presentation loaded prior to your slot.
Sir, is my presentation visible to you?
Yeah, it's visible. You can start.
Perfect. Thank you so much. So basically, today I'll be discussing the topic of do geographical indications offer ample and sufficient protection for indigenous craft traditions in India? And it's a doctrinal analysis. So I'm relying on more towards secondary sources as opposed to actual data that I would have collected myself. So before we move on to the actual analysis, I would just like to give you the basic definition behind geographical indications and indigenous craft traditions and how they basically are intertwined in the Indian scenario. So basically, geographical indications are any goods. That is what the GI Act says as per Section 21 F, that they are only covering goods which are natural, agriculture, or man-made, which are related to a particular area geographically, and because of that geographical relationship they derive their name and certain characteristics from that particular area. So if we go to the international agreement after which the GI Act came, which is the TRIPS agreement of 1995, it talks about two kinds of geographical indications. One is indications of source, that I just let us say Nagpuri orange because it is growing in the Nagpur area of India. But then there is another part of GI, that is appellations of origin, which is currently not imbibed in the Indian GI Act, but which I will also be discussing as a lacuna. It talks about that when you are talking about a particular product having originated from a particular state, it is not just about the final product that we need to protect, we also need to talk about the process, the knowledge, the raw materials, the practices that have actually gone into the creation of that particular product, which makes it into its current situation as it is now. And then that product should be protected, because if we just protect the product, there's a huge possibility of replication, misappropriation. But when we protect the process with the product, there's a huge possibility that the benefits actually go to the people who created, the artisans, the community, the indigenous people, that the knowledge is protected. So a lot of times when we talk about indigenous crafts and we talk about GI, we are dealing with knowledge that is not highly documented in nature. So if that process is also given protection, then we can actually make sure that the proper access and benefit sharing is being given to these indigenous people. In brief, if I have to explain indigenous craft traditions, they would just be that, just give you a simple example. If we take the Madhubani paintings, there are certain lines that are made, there are certain motifs, there are certain colors, there are certain tantra patterns that are used in it, which actually make it specific to that community. Let us say, granted GI tag granted in 2007 for Mithila, Bihar. So now that we have a basic understanding of geographical indication and indigenous craft, my major research question for this paper is that are geographical indications sufficient in protecting indigenous craft traditions, or they merely protect the commercial aspect, that is the product, without giving any actual benefit to the creators of that particular craft. So in this scenario, a very relevant question that can come up in being is that I have only highlighted about talking about the Geographical Indications Act of 1999. I have not spoken about the traditional
Participant,
knowledge below 20.
participant, you can move to the recommendation and suggestion.
Okay, sir. Sir, if you would allow me to just cover this particular slide and the next one, then I can end, if that is all right.
Okay, you can like go. Due to the capacity of time, we cannot look to every slide.
I particularly understand, but this is important for me to actually make my recommendations. Hence, I'm just requesting 2 minutes. I'll finish
All
up.
right. All right.
Thank you so much, sir, for the consideration. So now when we actually talk about the fact that I have spoken two words here, which is one is geographical indications, one is traditional knowledge. So first of all, we actually have to see that indigenous craft traditions are an amalgamation of the two. It is not completely protected under geographical indications, and we do not have an active law in India that protects traditional knowledge. So in this particular scenario, we can come to this conclusion that the protections offered to indigenous craft traditions are not complete, and hence an overhaul of the law is actually required. So either we amend the law that as it is, because it is archaic. It came into being in 1999, it was enforced in 2003, and now it's been almost 22 years and there's been no major amendment in the current law. So if I just take the scenario, a look at actuality about the Madhubani paintings of Mithila. So this is something that I've pulled from the research by the IPR cell of NSU RL Ranchi, and they've actually said that there is no awareness about protections within the artisanal communities, which they would have had if traditional knowledge and community heritage was given due advantage. There is continued misappropriation of the assets that the community is creating. There is no consent of, like, FPIC is a term that we use, free and informed consent. There is nothing like that. It only focuses on commodification, then actual preservation of heritage and giving back to the marginalized communities. So with this dichotomy, it comes makes me come to my recommendations that since indigenous craft traditions lie at an intersection of both of these regimes, it is important to recalibrate the whole work, or actually bring about a sui generis framework to make it better. So now again the argument comes that a traditional knowledge bill is already there, tabled way back in 2022 by Dr. Shashi Tharoor, but then that bill is also not bereft of lacunas. Like if I were to mention just 2 points that could be changed, it talks about government owning all the assets. But then if the government owns all the assets, what about the community-centric approach? What about collective participation? What about access and benefit sharing? We could actually borrow from systems of other South Asian compatriot jurisdictions, like in Malaysia, like in Indonesia. They actually have community-centric ownership of geographical indications, which focuses on the betterment of the artisans. It focuses on communal knowledge. It focuses on traditional processes and traditional cultural expressions. And the second part, which I highlighted in the beginning, is that a lot of our traditions which actually create tangible products are not documented. So even if that bill was to pass through, it would only be able to protect that which is written on paper. Like if let us say I am a Punjabi and I am making fulkari, I have been taught by my grandmother, or been taught by my mother, or have been taught by the other ladies of my family. There's no documentation. So in this case, if I were to better from it, then I should get protection because I'm a part of a certain community and I'm creating products that are commercially viable and they should be internationally recognized. And if I were to come to the recommendations of what could actually be imbibed in the current law, or to be created a new law where we talk about GI, traditional knowledge, and traditional cultural expressions, I would first of all like to emphasize that integration of the three should be there. There should be a community-centric approach. Proper mechanisms of access and benefit sharing should be there. There should be an element of community consent. There should be actual institutions which educate these marginalized communities who produce indigenous crafts to know that they have these protections and that they can use them, and the protection should not be just in the hands of the few, like maybe the government or the producer groups are organized. It should go down to the grassroots level. And then we also have to basically shift from a market oriented mind work to a welfare centric legal framework. So any questions?
There's no question for you. Thank you for your presentation.
Thank you so much, sir, for your time. And do you have any suggestions for me which I can improve upon?
There is no suggestions as such, but if you're looking forward for the geographical indication, you can take some of the country standards. Germany is working so good, you can look into the Germany's model.
Okay, thank you so much, sir. That means a lot.
Okay.
Okay, next we have Asmita and Nafesa.
Is my screen audible? Am I audible?
Yes, you are audible and visible. You can start with your presentation.
Yeah, okay. First of all, I apologize for my inconvenience and technological error, and I'm starting my presentation. So yeah, so me and my co-author have been legally researched on this topic, which is intellectual property issues in social media content creation and influence economic, legal aspect, and contemporary challenges. So, what is IP? We all know, which is creation of mind, which we have created by in our own means, and we are inventing something which can be anything like design, symbol, names, inventions, music, or anything it can be. It is a creation that we make, okay, but in this digital era the creation is being like a easily accessible to every creators, and they are also infringing it. For example, if a trend is being newly popular in the social media platform, every creator is using the trend, and we are not able to find the original owner who created it and the music. So when it comes to the songs or the music, or even the tune or BGM or any part of the music that has been originally patented or copyrighted are being used in the reels and trends which is being popular. This is infringing the copyright. So they are easily distributed, consumed, and creators are using it without any difficulties. So the next is the definition of IP in the digital world. So, as I said before, the video, the music, the software, the designs, or any part of the social media content which is available in the internet is being protected under Copyrights Act 1957. And nowadays it is being misused, as I said, as if we can say, if we put a prompt in AI and we ask it to generate any sort of information, it takes relevant issues from other parts of the internet itself. So it is giving the sources which is being authorized by another person. So if we are going to take it and use it again to our in our media platform, it is an infringement of their content. In WIPO report 2024, they have said that 80% of IP disputes involved in social media content only. This is because of we could not find the real owner itself, because we have lots of duplicate owners and duplicate replicas of the real owner content. We could not find the real owner itself. And the influence economy, as influence stands for a brand commerce. Sorry, sir? Shall I continue?
Yes, continue.
Yeah. So the influence market, the influence, as we all know, influencers are the persons who's like promoting any brand or any product to the commoner people, and they do or have strong influence in food
Move to the
sector.
suggestions and recommendation.
These are the introductions, sir, like what and all are happening in the society. So the recommendation will be in the end of the slide.
You can come to the challenges and then move to the recommendation and suggestion. That's what I'm asking.
Okay, so the challenges and recommendation will be followed by my co-author Nafisa. Nafisa, please take the panel.
Good afternoon, respected dignitaries. Let us move to the conclusion and suggestion. In this robust IPR regime fuels innovation and investment in Indian influencer economy. While balancing a creator rights and public access, suggestion focus on targeted to reforms to build a fair digital place. This honor creators and sustain growth's key conclusion, which said strong IP laws which needs protection with fair access and all vital rule for digital bloom. India needs precise UGC rule fair use, reforms to power creator and first economy. Your content is your empire. Don't let thief wins. Thank you. This is our suggestion and conclusion for the robust IPO regime. Thank you, sir. Is there any
Thank
questions?
There's no question for you, participant. We can move to the next.
Thank you so much, sir.
Next up, we have Arushi Agarwal and Shreya Mulabgul.
Good afternoon, rather. My co-author will be sharing her slide. Am I audible?
Yes, you're audible.
Thank you. Shreya?
Both the participant, you have to turn on your camera.
Yes, we're doing that.
Participant slides are not visible.
So just 1 minute.
Yeah, it's visible.
Okay.
Showing. Let's start with the presentation.
All right. So a very good afternoon to everyone. So today, me and my co-author Shreya Mulbagal, we are going to give a presentation on the topic, the evolving threat to fashion inside the rise of superfakes. But before we move on to that, to understand the fashion industry, we must first look at its architectural background, intellectual property. Fashion isn't just about utility, it's about a brand's narrative and creative integrity. For this, we rely on four primary pillars of protection: trademarks, copyrights, patents, and trade secrets. Trademarks are vital for protecting logos and brands' ethos, serving as a powerful deterrent against counterfeiters. Copyrights. They shield graphical elements and the creative structure of a design. Patents are essential for securing technical innovations such as smart textiles or new manufacturing processes. Trade secrets protect designs and styles in the vulnerable stages before they are released to the public. Together, these rights foster innovation and enable fair competition in a global market. Now, moving on to the threat landscape. Despite all of these protections, the industry faces a rapidly evolving threat landscape. The rise of superfakes has become a primary concern. Superfakes are essentially sophisticated replicas so well made that they can deceive even the most savviest consumers, leading to massive financial losses. Beyond direct copying, we see brand dilution and gray markets. Now, brand dilution occurs when a brand's distinctiveness is weakened through unauthorized use, even without direct competition. Now, what are gray markets? They are basically when authentic goods are sold through unauthorized channels at lower prices. These undermine a brand's pricing strategy to the core. We need to understand that digitalization has acted as a double edged sword. While I agree it allows for global reach and so many other benefits, it also facilitates large scale unauthorized imitation, from AI generated content to unauthorized virtual products in the metaverse. Digital tools are making it harder than ever to protect a brand's visual identity. Now, my co-author Shreya would continue ahead.
Thank you, Arushi. Now I shall be moving on to the next point, which is the ultra fast fashion paradigm. Now, talking about this, as we already know that the industry has moved from a 4 seasonal cycle to a 52-week trend cycle. Now, because of this, the ultra fast fashion companies are using AI driven tools to predict the trends from the luxury brands and then imitate those designs and then recreate them to sell them at a lower price. Now, this is disadvantage to the luxury companies, firstly because of the economic aspect as well as the legal aspect. Now, talking about the legal aspect, it is why because the fast fashion companies use the defense of calling it an inspiration rather than blatant imitation, because of which they're able to bypass the legal infringement. Now, talking about what the uh, IPR in the case of the European Union and the USA when it comes to the IPR protection. Talking about the European Union, which follows CDR, they offer a 3-year protection for both registered and the unregistered designs, which helps to cover all sorts of broad aspects when it comes to designs which are long term as well as short term. The United States offers a more high threshold protection where there is a separability test based on whether the design consists of a purely an aesthetic value or functionality. When it comes to aesthetic value, then only the USA will provide IP protection. But in case of functionality, such as a garment cut or any design which furthers the use of the garment, will not be considered. Because of this, there's a huge
Participant move to the recommendation and suggestion.
Okay, sir. I shall move to that. So the solutions and recommendations for this scenario is firstly that the the most universal thing is that they should uh, create a uniform civil code, like a uniform law when it comes to IPR, that there should be harmonization. Every single country must follow a similar IPR pattern which covers most of the broad aspects. Secondly, when it comes to flexibility, the IP laws which are created must be flexible in nature so that they can accommodate the future technological changes that happen at a rapid pace. And there's no gap between the rights as well as the technological development. And in case of policies, there should be special IP codes and a stay down approach for e-commerce section. And in case of AI monitoring, AI can serve as a both boon and a bane when it comes to either scanning all of the designs so that it can detect imitation, as well as again it can be used for imitation. So there must be a better use of AI in this case. Now, my co-author will conclude.
So, to give a brief introduction, I would like to say that by embracing these innovations, we can ensure that the intangible soul of fashion remains protected and motivated to create. Thank you so much.
Thank you so much, sir.
Okay, there's
Are
no
there any
question for
questions?
you. No, there's no question for you.
Any feedback?
Specifically, there is no such suggestions I can provide you on the designs. You can look into one of the legislation like last year. In the month of September, I believe there is a declaration which is made in Saudi. You can look into that, and also uh, one of the country like Italy is known for the legislations on the designs. You can also look into the model Italian laws on the designs.
All right.
Okay,
Thank you so much.
thank you so much,
Yeah.
sir.
Next, we have Gayatri and Pawan.
Am I visible, sir? I'm also audible.
Yes, you are visible and audible.
Okay, thank you.
Participant, kindly present your screen.
Yeah. Okay. Can I start?
Yes, you can start.
Good afternoon. I'm Gayatri Nair, and this paper is co-authored with Pavan Rakesh. So today I'll be presenting our paper titled AI Generated Works and the Moral Right Challenges, Safeguarding the Human Creativity.
Artificial intelligence has rapidly entered into the creative domains, generating text, images, music, and audiovisual works with a minimal human interventions. So, this development presents a serious challenge to the copyright law, which has traditionally been anchored into the human authorship, intellectual agency, and the moral responsibility. So, as AI generated content proliferates, established standards of originality and moral rights are facing growing uncertainty. So, these uncertainty has significant implications for the courts as well as for the policymakers responsible for striking a balance between the technological innovations as well as protection of the human creativity. So, this paper examines how copyright law should respond to the authorship challenges arising from the AI generated content while preserving the human dignity as well as the moral accountability. So the statement of problem is that the increasing use of artificial intelligence in creative process has unsettled copyright law, which is fundamentally built on human authorship and moral personality. So when AI systems can generate expressive works with the human input, like minimal human input, the law provides limited clarity on how the authorship and the moral rights should be applied to these works. So this creates a risk of either creating machines as author or weakening the protections traditionally afforded to the human creators, so making it difficult to balance the innovation and the preservation of human creativity. So basically, this paper focuses on three main concerns. First, whether AI generated contents or the works can meet the existing standards of authorship and originality. Second, how different jurisdictions approach authorship in AI generated and AI assisted works. And third, how the moral rights rooted in human dignity are affected by the AI created contents. So the moral rights under the copyright law are grounded in the human dignity and personality, and the rights of attribution and integrity presuppose an author capable of honor, reputation, and moral harm. So these rights arise from the personal and enduring relationships between a creator and their work. Like there are many theories that justify this. Like the works reflect the author's personality. So artificial intelligence lacks consciousness, intent, moral personality, cannot experience a reputation or dignitary injury, and therefore falls outside the conceptual foundations of the moral rights. So Indian courts have consistently reaffirmed this human-centric understanding, particularly in the cases of Amarnath Sehgal versus Union of India, Manu versus Kala Vikas Pictures, where moral rights were recognized and as personal and inseparable from the human author. So extending moral rights to AI would dilute this ethical foundation by serving the authorship from the human dignity. Uh, Conducting a comparative examination of the US, UK, and the India reveals a shared premise that the authorship under copyright law continues to be treated as a distinctly human concept, even after the technological advancements. So, in US, the courts have adopted a stricter requirement of human authorship. In Talal versus Perlmutter case, AI generated works were deemed ineligible for copyright protection, providing doctrinal clarity but limiting the flexibility. Coming to UK, it adopts a functional approach through an arranger, which is defined in Section 9, Clause 3 of the Copyright Designs and Patents Act of 1988, which attributes authorship to the person who makes the necessary arrangements. While this ensures
Participant
that.
suggestions and recommendation.
Yes, okay, sir. Um, the challenges posed by the artificial intelligence arise because of the copyright law, which is built on human intention and morality. So this what I suggest is that the human authorship it should depend like in a normative baseline resolves that human authorship should be considered, this by ensuring that the copyright protection is granted only where human creative agency can be clearly identified. Second, existing originality tests were developed for the human creators, which provide limited guidance in AI assisted context. So this uncertainty can be addressed through a threshold based approach such as human creative control threshold, which clarifies where human involvement crosses the level required for authorship by focusing on creative control rather than a mere AI usage, like a mere prompting is not sufficient. And third, the moral rights are grounded in human dignity, reputation, and personal identity. Since AI cannot experience reputational or moral harm, extending moral rights to non-sentient entities would undermine the ethical foundation of AI. So, statutory clarifications limiting the moral rights to natural persons therefore preserves this coherence. When AI involvement in creative works is obscured, there is a risk of misattribution or dilution of human creativity. So, strengthening the attribution safeguards to clear labeling and remedies against a false attribution ensures that the human creators receive a proper recognition and protection. Finally, the disclosure and transparency obligations are necessary to enable the courts and regulators to assess the extent of human contributions in AI assisted works. So, requiring the disclosure of AI use and documentation of human creative inputs provides a consistent evidentiary value or evidentiary basis for applying authorship standards. So, taken together, these measures allow copyright law to adapt procedurally to artificial intelligence while preserving the human centric foundations and the ethical integrity. Thank you,
Okay,
sir.
thank you. Thank you, participant, for your presentation. There is no
Thank you
such
so much,
question.
sir. Thank you.
Next, we have Tejas and Shaurya from NLU Jodhpur.
Am I audible?
Yes, you are audible. You can share your presentation.
Is the presentation visible to everyone? Hello?
Yes, you can start with your presentation, team.
Okay. I extend my sincere greetings to everyone present here. My name is Shaurya Singh, here today with my good friend Tejas Modi, and we both are presenting our paper titled Recalibrating Intellectual Property in the Age of AI Indigenous Convergence, a South Asian Model for Hybrid Innovation Governance. Every paper and every idea has a motivation and aim of the author behind it. Our motivation is that we were studying a peculiar chapter in our curriculum for history, the deindustrialization of India. One key instrument was the stripping away of IPR by the Britishers from the commoners, which was done by using the Patents and Designs Act of 1911. While it's not racist in its form, it is actually racist in nature because of the many ways which our paper has explored. Our paper aims to study how the colonial IP regimes damaged South Asian IPR, how did these countries rebuild after independence, and how are they doing now, and what will AI do to their IPR governance. And we also want to propose an IPR alliance and what it should have. South Asia was one of the most innovative continents to ever exist in our whole history. It had a great system for IPR management and IPR usage. It was made for the community by the community, which is very contradictory to the standards of Europeans, which is individualism, authoritarianism, and written fixation. With the coming of colonial laws, it redefined South Asian IPR jurisprudence forever. Agricultural practices, food practices, etc., and many of South Asian delicacies were taken away by the Europeans in the name of copyright and IPR, which is one of the reasons why today's regimes are struggling a lot. Even after gaining their independence, their IPR jurisprudence was left in neglect because many of these nations had to tackle many growing issues like industrialization, wars, land reforms. And that's why many nations still took to the Patents and Designs Act of 1911, mainly focusing on the Indian subcontinent. Nations like Bangladesh and Pakistan didn't even have their own IPR law until the 2000s. Now the main author Tejas Modi will take over.
Thank you, Shaurya. From the early 2000s, South Asian countries began moving away from colonial intellectual property laws. India amended its patent law in 2005. Pakistan introduced the Patents Ordinance in 2000, and Bangladesh and Sri Lanka updated their IP regimes. These reforms marked a shift toward innovation-oriented governance. However, they occurred independently, leading to modernization without regional coherence. Landmark judgments which have been pronounced in the nations are a reflection of different paths they follow and also expose their weakness of a divided path. Existing platforms like SARC and BRICS lack binding coordination. So, what we propose is a basic framework for an IP alliance for South Asia. This lack of regional coherence becomes especially problematic in the age of artificial intelligence. AI systems today are trained on South Asian languages, traditional medicine, agriculture, and cultural archives. Once digitalized, this knowledge is treated as neutral data, disconnected from the communities that created it, allowing private entities to extract value without consent or benefit sharing. This creates a serious risk of digital colonialism. To conclude, sorry, national intellectual property reforms alone are insufficient because traditional knowledge systems are transboundary. We therefore propose a South Asian IP cooperation framework based on shared custodianship, ethical AI standards, and coordinated participation in global IP negotiations. To summarize, South Asia's intellectual property systems continue to reflect colonial disruptions, now intensified by AI driven knowledge extraction. Without regional coordination, technological progress risks repeating historical injustice. A cooperative South Asian IP framework offers a balanced path that protects community knowledge while supporting innovation in the digital age. Thank you for your time. Are there any suggestions for us?
There is no such suggestions. I will prefer you to look into some of the model countries for your paper and to come up with the applicable country model for India.
Okay, sir. Thank you.
Yes. We can move
Next,
ahead
we
to the
have
next.
Akansha from Christ University.
Actually, sir, your voice is breaking. Can you please repeat?
Sir, I hope my PPT is visible.
Yes, it's visible.
Uh,
Yes, participant, you can start with your presentation.
okay, sir. So good afternoon, everyone. And my name is Akanksha, and today I'll be presenting my paper titled "Do Consumers Recognize Authentic Geographical Indication Products?" which is an empirical study on awareness and buying behavior. The core conflict that we often hear is that geographical indications protect tradition, support artisans, and enhance exports. Yet, despite strong legal frameworks, there is not a single mainstream consumer truly understands what a GI label actually means at the point of purchase. This is the central question of my research, which I investigated, that whether why does an authenticity label that is legally protected fails to trigger the recognition and trust among the consumers. So the two recent developments illustrate these problems with the striking clarity. That is the Ponduru Khadi, which gets the GI tag in 2025, which was a fabric once praised by Mahatma Gandhi that received a GI tag after decades of cultural significance. And the government reports highlight that GI tagging is now being fast tracked to boost local economies and global cultural branding. However, without proper consumer recognition, this legal success means a very short span in the real market. The fabric may be GI protected, but if the buyers cannot identify or trust that level, the economic value is lost for that product. Similarly, the second surge of GI application in West Bengal, that the chief minister announced that the state plans to integrate thousands of products into GI system, which is far more than its current 36 GI tags to support local artisans and to boost the exports. Also, the main theme of the paper, which is the missing link, that India has robust legal mechanisms to protect the GI products, yet the system fails where it matters the most, that is in the mind of consumers and at the point of sale. And this is not a legal problem, it is a market communication problem. When we legally understands the geographical indications, it is identified under the TRIPS agreement and the GI Act of 1999, but law only regulates the supply side. The market operates on trust signals. And now the crucial insight is that GI have to function as signals, not just legal title, but many of them don't do it much.
Different countries have adopted different strategies, like the EU model, where there are standardized logos and mandatory labeling, along with strong enforcement, where consumers could recognize the GI products and associate with them the quality. Similarly, in China, as of 2025, it has almost 4,100 registered GI products, many of which are recognized overseas. And this expansion reflects a strategic GI as brand building tool, but also reinforces the need for the consumer visibility. And India, which has one of the largest GI registries in the world, there is no uniform GI logo, no national consumer awareness campaigns, and also a weak online verification system. This means authenticity exists on paper but not in perception. Now, the theoretical insight is that the all economists call credescence goods to be as GI, the product whose quality cannot be verified by consumers even after the purchase. For example, when a buyer sitting in Mumbai confirms that the tea packet is labeled as Darjeeling tea, is genuinely grown in Darjeeling. If the level is unclear, poorly visible, or absent, the consumer subtitles other signals like brand name, pricing, or packaging. This illustrates why labeling and perception matters more than the legal titles. So I went through an empirical study where I sampled almost 49 to 50 people's primarily educated and frequent buyers of regional products. Here is what I found: that awareness is very shallow, and most respondents have heard about GIs, but very few understand what GI level signifies legally or culturally. And only 25% of the respondents reported that they could confidently identify authentic GI products while shopping. And while 72.9% of the consumers said that the authenticity was very important, and the majority admitted that they doubted GI claims frequently, especially on online market where the misuse of GI names is common. Now, the policy implications that I would like to suggest is that I would like to argue that the current GI protection model in India is registration centric. Success is measured only by how many products are GI tagged, and it is not consumer centric, and it is not measured through the consumer recognition or trust, which needs a change. And my research suggests a deeper institutional shifts from by
Participant,
mandating.
kindly conclude.
Yes, sir. This is the last part. I would like to suggest that there should be a deeper institutional shift, that a mandate a national GI logo and a single recognizable symbol, like in the EU. They have provided PGI labels which are visible on every GI products, both online and offline, and also use blockchain and traceability tools to allow consumers to scan them, verify them, and trust, which will build trust. And the most important is educate at the point of sale. Consumer education is very necessary to shift to activation and not to awareness, and makes levels that explain what GI means, and countrywide campaigns which are similar to the true Italian tastes by the EU. To conclude, geographical indication protection in India is strong on paper but weak in consumer perceptions. Legal success has not translated into market trust. If a label cannot convince a buyer standing in front of a shelf, it fails the core purpose, that is the authentic differentiation. So GI protection must evolve from law to perception. Only then it could fulfill the promise of empowering producers, protect heritage, and enhance the consumer
All
value.
right, participant. My one suggestion to you is, recently DPIT of Ministry of Commerce has issued a direction regarding the amendment of GI Act of 2000, like for India. Now,
Okay.
it is my suggestion to visit all those recommendation and commentaries which DPIT has released till now, and looked into to incorporate in your paper. What are the policy changes India is coming up? What are the
Okay.
analysis of those changes? What are the thing after the implementation of changes the India will have? That's the
Okay,
thing you should incorporate.
okay, sir.
Yes, the host. We can move ahead with the next.
Next, we have Aditi Anupama Bhaskar.
Yes. Am I audible?
Yes, you're
Yes, you're
audible, but
audible,
your
but
camera is not turned on.
Uh,
all the participants kindly make sure you are having your PPT loaded prior to your slot. Okay, without any delay, we can move to the next host.
Yes, sir. So next we have Aniket Sharma and Chirag Agarwal from OP Jindal University. Okay,
Participants, you
are
are
you
not
guys
visible.
present?
Hello, am I audible?
Yes,
Yes,
you're
you are.
audible, but you're not visible.
I cannot hear you.
Am I audible?
Hello.
Participants, both of you are not visible. You are just audible. Your slides are visible, but you are not
Um,
visible.
can I start?
You are not visible, you cannot start. You have to turn on your camera. Yes, you can start. Yeah. Yes, now you can start.
Hello.
Yes, start.
Okay. Thank you. So today, me, Chirag Agarwal, and Aniket Sharma are going to present our paper titled "Between Innovation and Access: Re-examining FRAND licensing in the age of 5G standard essential
Am
patents."
I audible, sir?
So,
Hello.
as we all know that 5G,
Yes,
the
you are
coming
audible.
of 5G networks has been a turning point in the progression
I
of
can't hear any
technologies.
voice.
There are some estimates which state that 5G will contribute an estimated of $13.2 trillion to the global economy in the decade from 2020 to 2035. However, this realization of 5G and the interconnected technologies rests on a complex legal and technological foundation that is built upon standard essential patents (SEPs) and fair, reasonable, and non-discriminatory, that is FRAND licensing. It is on this basis that this paper considers the possibility that whether the current FRAND regime that prevails under the global SEP regulations is balanced enough to spur innovation and at the same time improve competition comprehensively in the 5G rollout. Uh, we have divided this paper into four chapters. The first chapter deals with the legal framework of SCPs and FRAND. The second chapter deals with FRAND and the global 5G ecosystem. Third chapter is where we have done a comparative jurisdictional analysis between the different jurisdictions such as US, India, etc., and how do they deal with SEPs and FRAND. And the final chapter is where we have recognized some challenges and also uh, propose some solutions and proposals to better implement the SEP on worldwide. Uh, so this is the first chapter, legal framework of SCPs and FRAND. We deal with what are SCPs, the lock-in effect of SCPs, the role of FRAND and in 5G licensing. And we have basically identified three distinct approaches in Europe, United States, and India in this chapter. Uh, the next chapter is with regards to FRAND and the global 5G ecosystem. We have seen that uh, so, due to the paucity of time, I'll move on to the next chapter, which is a comparative jurisdictional analysis, which Aniket uh, uh, will go with.
Thank you, Chirag. So, good afternoon. So, I will begin with a comparative analysis of how different jurisdictions interpret FRAND obligation for standard essential patents in the context of 5G.
Aniket,
So,
we
in the
can't hear you.
European, uh, just a second.
No, no, Aniket, you are perfectly audible. Please continue.
Okay, sir, sorry. So, in the European Union, FRAND is treated primarily as a competition law obligation. So, as we analyze the Huawei versus ZTE decision that required SEP holders to follow a structured negotiation process before seeking injunctions, ensuring procedural fairness and preventing abuse of dominance. Later, the case of Unwired Planet allowed national courts to determine global FRAND rates, reflecting the international nature of 5G standards, but also raising concerns of jurisdictional overreach. So, in the United States, by contrast, follows a contract based and market oriented approach. The courts view FRAND commitments as private contractual promises made to standard setting organizations. Also, in FTC versus Qualcomm, the courts rejected the use of antitrust
Participant,
law
you
to
can move to
regulate.
the suggestion and recommendation.
Yes, sir.
You can move to the suggestion and recommendations.
Okay, sir. So, as I discussed, these divergent approaches have created significant challenges for the global FRAND regime. First is the inconsistent standard, encouraging forum shopping, where parties strategically choose jurisdictions that offer favorable outcomes. Second, conflicting injunctions and anti suit orders that undermine legal certainty. Thirdly, royalty stacking and unequal bargaining power, particularly disadvantage smaller implementers and developing economies. So, to address these issues, several reform proposals have emerged. At the regional level, the European Union's proposed SEP regulation seeks to introduce centralized, essentially assessments, transparent registries, and structured FRAND rate determination to improve predictability. At the international level, WIPO led mediation and arbitration frameworks have been proposed to offer neutral transnational dispute resolution outside domestic outside domestic courts. Patent pools such as Avanci also aims to simplify licensing, though they raise antitrust concerns. Ultimately, our paper argues that only a coordinated transnational FRAND governance framework can reconcile innovation incentives with fair and equitable access in the global 5G ecosystem. Thank you, sir.
Okay, there's no question for you, team. We can move ahead with the next participant.
Thank you.
Next, we have Aditi Anupama Bhaskar.
Yes. Am I audible?
Yes, you are audible.
Participant, kindly present your screen.
Yes. Is this visible?
Yeah, it's visible.
Good afternoon, everyone. My paper is titled The Public Domain Vacuum, that is, Reimagining Collective Sovereignty and the Protection of Performative Heritage in the Age of Generative AI. Now, this work is crucial because currently we are witnessing the complete fencing off of entire community heritages by the legal system because they refuse to recognize them, which leads to their mass misappropriation or commonly referred to as cultural appropriation. Now, the problem that is core issue is the structural flaw of conventional IP, that is the requirement of fixation, that is a rigid definition which performative heritage like dance or oral rituals cannot fulfill because they are by nature dynamic and unfixed. Therefore, they fall into this legal vacuum, and this legal vacuum is quite exploited by AI developers because they use this as a free territory. They scrape the internet for petabytes of data to train their AI models, which effectively transforms these cultural assets into raw commodities for commercial models without the consent of the custodians, which doesn't just become theft, but industrial scale digital extraction, which is just exacerbating the historical biopiracy. The gap becomes the current legislation. That is, while the WIPO GRATK treaty, that is the Genetic Resources and Associated Traditional Knowledge Treaty that was adopted in May 2024, was a landmark achievement. It very blatantly left out performative heritages within its framework. And furthermore, even defensive models like India's traditional knowledge and digital library only prevents erroneous patents while not offering any positive rights. And also, Western authorship, that is, Western definitions of IP rights, they do not recognize cultural heritage in any way. Therefore, the research goal of my paper is to fill this legal vacuum by proposing a shift from the defensive measures to assertive sovereignty. I introduce Archer, the Assertive Regional and Cultural Hybrid Expressions Registry. The goal is to establish a global policy framework which combines this mandatory positive sui generis rights with the technological infrastructure to enforce them even in the digital environment. Now, the methodology that I used was first the analysis of the intellectual property that is already present. As you can see, it began from dissecting the public domain to identify the legal vacuum, followed by the evaluation of South Africa's IKS, or the uh, yes, South Africa's IKS and India's TKDL models. And combining this, I propose the Archer framework, which moves beyond just a traditional IP framework and enforces even the digital data poisoning or watermarking. Now, coming to the core finding, that is the Archer model as the primary solution. By combining the rights within South Africa's IKS and Indian TKDL, it provides infrastructure and positive rights. By differentiating the levels of protection for sacred versus a secular heritage, there is tiered rights available within the framework. And thereby, you also give sovereignty to the community themselves so that they have the right to give or assign any license or allowing this commercialization of their assets. And finally, the regulatory nexus must then be shifted by mandating PIC, that is prior informed consent, and EBS, equitable benefit sharing. You are regulating the AI ingestion at the point itself. And by protecting the dynamic, oral, and fleeting performance by law, there is assurance that AI developers must always meet up with these communities before they are exploiting them. Now, coming to the digital enforcement, by shifting what AI cannot do to what AI cannot ingest, we are making an important mark. And further, data poisoning, such as pixelization of images so that it cannot be exploited by AI, is also a significant aspect. And
Participant move
thirdly,
to suggestion and recommendation.
okay, yes, sir. Uh, yes. Further, to prevent the complete closing off of human heritage, we replace this fixation requirement by put forward by the Western IP framework, and we enforce collective rights and provide sovereignty and collective sovereignty to the culture. Thank you.
Okay, thank you for your presentation. We can move with the next participant.
Up next, we have Apurva Shukla.
Hello, sir. Am I audible?
Yes, you're
Yes, you
audible,
are.
but you're not visible.
Yes.
Yes, you're
Yes, am I
visible.
audible now? Yeah. Just 1 second. I'll share my presentation. Good afternoon, everybody. The presentation that on the paper that we have written today is on the framework level gap analysis of the India's Geographical Indications Act when it is compared to international standards. So the paper has been very India centric, very nation centric, because we are assessing the domestic limitations, we are assessing the framework of our country and how it's posing international vulnerabilities when we compare it against the Lisbon system. So the Lisbon system basically consists of both the Lisbon Agreement of 1958 and the Geneva Act. And as the domestic legislation, we are going to talk about Geographical Indications Act of 1999. So this has been the structure of the paper. And moving on to India's framework, we are for sure TRIPS compliant because the India's GI Act came about only after TRIPS was enacted, and TRIPS has set out the minimum standards and complying with that. Of course, after the Basmati rice controversy, where India had this case against a rice tech company in the US, we had to enact the GI Act for a stronger, more compliant system of management of our own geographical commodities. So the geographical indications identify a good where a given quality, reputation, or some characteristics is essentially attributable to the geographical origin. This is called the essentially attributable test, and the appellation of origin is where the geographical denomination which designates a product, the quality or all of the characteristics of this product have to be exclusively or essentially come from that geographical environment only. That is what makes the geographical indication and the appellation of origin different, because the standard we are asking for is very different. Appellation of origin requires a very very high standard. That is why you cannot call any other kind of sparkling wine as champagne unless all of the stages have been done inside the Champagne region of France. So the central argument is that India's GI Act is fulfilling the minimum obligations, but it is still not ensuring complete protection to the commodities that we have. So there are two tiers of protection. The first tier is the Lisbon system, the Geneva Act. This is the gold standard of protection. Unfortunately, India is not a part of this system, but we are a part of WTO, and that's why we are TRIPS compliant, which is the minimum standard compliance. TRIPS, unfortunately, again, does not recognize anything as a sorry, appellation of origins as a separate category. It has only two categories which come under Article 22 and Article 23, and the Lisbon system does give us a better gold standard protection because the qualitative link is very strong when it comes to the geographical region. Now, what are the internal cracks in our system? There are a lot of procedural challenges. The registration process is very tedious. It is a very lengthy, it is a multi-stage process. There is a lot of genericization, which is when you get one geographical indication, it becomes very generic, and that is why there is a high risk of one product becoming very generic under that indication. Then there is absence of a separate category. Of course, there are socioeconomic barriers because the benefits do not reach the poor artisans, the low level creators, but they are obviously lost among the middlemen. And of course, there is a very low amount of awareness amongst people of what product is actually coming from that area and what is a fake or counterfeit product. Then we have geographical and structural hurdles. Of course, unlike other IPR offices, the GI office is very centralized. It is only located in Chennai, while other offices are located all across India. In the international arena, the flawed system of protection is because there is a dichotomy that TRIPS itself has created. There is absolute protection under Article 23 and there is basic protection under Article 22. This is also known as TRIPS Article 23 controversy. Because of the Eurogay round, there was a lot of contention raised by EU and US, and the absolute protection was only granted to products which are wines and spirits, because these areas have a better manufacturing of wines and spirits. Now, India, much more known for its handicrafts, does not get this
Participants
absolute
kindly
protection.
move to the conclusion. It's already up
Sure,
time.
sure, sir. Okay. So these are the consequences: free riding and market dilution, and obviously economic loss. The path forward can be, first of all, a complete legal and administrative reform. We need to streamline the registration process, we need to decentralize the registry, we need expedite procedures, we need post registration support for the market, we need to empower artisans, we need to empower manufacturers so that they get the benefits of their creations. And most importantly, India should seriously consider becoming a part of the Lisbon Agreement, because such strategic international alignment is going to afford us a higher level of protection, which comes under AO, appellations of origin. Thank you so much, sir. That is all.
Okay, participant, have you incorporated the recent recommendation changes which the DPIT has brought up for the GI Act?
Yes, sir. So the changes have been brought about to the registration procedure for sure. The fees has been reduced about up till 80%, but the problem is still that
My
the
question,
registry.
my question is, have you analyzed it in your paper?
No, sir. The paper has not analyzed the recent amendment, because we are talking about decentralization of the registry, which the amendment is not talking about.
But still, like decentralization is a major portion, that is well and good, but you should looked into the implementation of the amendments which is recently taken into consideration, and what is the effect of the implementation of those amendments in the registry, whether these amendments can come up with more number of GI registration in India. So that's what you can look into, you have to look into. That's my suggestion. All right.
Sure, sir. Sure, sir. Thank you so much.
At last, we have Spandan Roy from NUJS.
Am I audible?
Yes, you're audible.
Just give me a minute. Is my screen visible?
Yes, participant, it is visible. You can start presenting.
Good afternoon to everyone present. I want to thank the respected authorities for giving me the opportunity to present my paper titled Patent Governance in Post-TRIPS World, Implication for Distributive Justice and Access to Medicines. Today, the question I'll be examining is whether intellectual property rights and human rights truly coexist. I want to begin with legal scholar Lawrence Elsworth's prediction of two possible futures. The first, a conflict theory, where patents fundamentally clash with the right to health. The second, a coexistence model, where both can be balanced through careful legal design. His key question was whether soft law instruments like the ICACR would influence hard law regimes like WTO TRIPS. By the end of the presentation, we'll assess whether his prediction came true using India's patent journey as our case study. Let me begin with the foundation, the right to health. The WHO Constitution in 1946 was the first to recognize health as a fundamental right. This was strengthened by the ICACR in 1966, which mandates states to ensure medical care and essential drugs for all. In India, our Supreme Court has interpreted Article 21 to include the right to health. The landmark Paschim Banga Khet Mazdoor Samiti versus State of West Bengal case held that governments have a primary duty to provide timely medical treatment. This is not just aspirational, it is an enforceable obligation. Access to medicine, therefore, sits at the intersection of law, dignity, and survival. Next, we have the tension. Patents grant 20-year monopolies to incentivize innovation and recover R&D costs. During this period, manufacturers can set prices without competition. The problem is that these monopoly prices often exclude the world's poorest populations. The WHO found in 2006 that IP protections have done little to incentivize research into diseases affecting developing nations. Doctors Without Borders put it starkly: patents kill when patients cannot afford. This raises a fundamental question: should life-saving medicines be treated as commodities or as public goods? This is where the conflict between IP and human rights becomes most visible. Entered TRIPS in 1995. Before TRIPS, IP was regulated by WIPO through non-binding standards. TRIPS changed everything by imposing binding minimum standards globally. 20 years patents, product patents for in all fields, and WTO enforcement mechanisms. Many scholars describe TRIPS as a corporate capture of international lawmaking driven by pharmaceutical industry lobbying. The HIV/AIDS crisis exposed its dangers when developing nations struggled to access medicine. This led to the Doha Declaration in 2001, which affirmed that TRIPS must support public health and authorize compulsory licensing. This was soft law beginning to push against the hard law. Now, if you see the India story, post-independence, the Iyengar committee found a shocking disparity. For every one patent granted to an Indian, 9 went to foreigners. The committee recommended that patent law must serve national economic needs, not just reward inventors. The 1970 Patents Act was revolutionary. It allowed only process patents for pharmaceuticals, not product patents. The result, India's generic industry flourished. By 2004, Indian companies controlled 77% of the domestic market compared to just 32% in 1970. This was India's golden era of affordable medicines, but TRIPS compliance would force a dramatic reversal. When India amended its law in 2005 to allow product patents, there was massive public opposition, but India did not simply capitulate. It introduced Section 3D, a brilliant legal innovation. Section 3D says new forms of known substances are not patentable unless they show enhanced efficacy. This prevents evergreening, where companies make trivial modifications to extend patent life. As scholar Shamnath Bashir noted, this was India's creative deployment of TRIPS flexibilities. It's not just a patentability test, it's a patent eligibility filter applied before other assessments. This became India's most significant tool to balance innovation with access. So Section 3D was tested in the landmark Novartis case in 2013. Novartis sought a patent for a beta crystalline form of imatinib mesylate, marketed as Gleevec for cancer treatment. They claimed beta storage properties, but there was a problem. Novartis charged 1.2 lakh per month, while generic versions cost only 8,000 to 10,000. The Supreme Court ruled that efficacy in pharmaceuticals means therapeutic efficacy. It is just concerned with the question, does the medicine treat the disease better? Improved storage or physiochemical properties do not count. Since Novartis could not prove enhanced therapeutic benefit, the patent was rejected. This judgment clarified that Section 3D blocks evergreening while still allowing genuine innovations. It was a watershed moment for Indian patent law. Now let's talk about compulsory licensing, another TRIPS flexibility. India has granted only one compulsory license post TRIPS in a BR Natco case in 2014. BS cancer drug Nexavar cost 2.8 lakh per month when average income was just 5,000. The court granted Natco a license to produce it in 8,800 at a 97% price reduction. But here's a problem. Despite legal authorization, compulsory licensing is rarely used. During COVID-19, despite severe shortages and court suggestions, India issued zero compulsory licenses. One of the biggest reasons behind non-employment of compulsory licensing is geopolitical pressure. The US actively opposes compulsory licensing and has sued countries for using it. This shows the gap between legal rights and practical implementation.
Participant move to the concluding part.
Okay, sir. So if we assess, did Helfer's prediction come true? The answer is partially yes. On the positive side, we see clear evidence of coexistence. Soft law has influenced hard law. At a national level, India Section 3D embeds the Novartis judgment applied constitutional principles. The court invoked ICSR in IP disputes. The Doha Declaration created space for the public health in TRIPS itself. However, tensions persist. Compulsory licensing remains underused due to geopolitical pressure. The US constitutes challenge countries that the TRIPS flexibilities. Even with 95% essential medicines off patent, a third of the world lacks access, showing that structural inequalities go beyond patents. I want to conclude with that we have achieved partial coexistence through creative national implementation and constitutional jurisprudence, but full harmonization remains constrained by global power dynamics. Thank you, sir.
So participant, like you had mentioned the Novartis judgment. After the setback of the Novartis judgment, there are certain policy changes also in the amendment segment. So have you mentioned all these amendments, whatever has been bought out of the Novartis?
No, sir, I have to look into that.
Okay, so take this as a suggestion. You have to incorporate this along with take the changes of the recent amendments of Patents Act in the rules, also regulations regarding the international patent, and make all those corporate like changes into your suggestions.
Okay, sir. Thank you.
So now that we are done with all the participants, should I move with the vote of thanks?
Yes.
Okay. As we bring this session of the South Asian Global Intellectual Property Conference 2025 to a close, I would like to extend my sincere thanks to everyone who contributed to making this conference both engaging and impactful. I begin by expressing my heartfelt appreciation to all our speakers and participants for their thoughtful contribution. Your insights on the evolving dimension of intellectual property, innovation, technology, and policy have added immense value to today's deliberations and truly reflect the spirit of this global platform. I would like to place on record our gratitude to the Center for Development of Intellectual Property and Research and the Naovina Development of Intellectual Property and Research Foundation for conceptualizing and organizing this conference with such vision and dedication. Our sincere thanks also goes to our global collaborators, Cambridge Teachers of Tomorrow, the Global Entrepreneurship Network, the Global Innovation Policy Center, and the Internet Governance Forum for their support and partnership in strengthening international academia and policy dialogue in the field of intellectual property. A special note of appreciation to our founder and director, Dr. Mr. Dipendu Das, whose leadership and commitment to advancing IP scholarship and global collaboration continue to shape initiatives of this scale and significance. I would also like to acknowledge the tireless effort of our organizing committee, as the second South Asian Global Intellectual Property Summit 2025 continues with more insightful session ahead. I encourage all the participants to stay connected and engaged. Wishing you all continued success and inspiration in your academic and professional journeys within the world of intellectual property. Thank you.